heaven. Hallowed be thy name, thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen.
This house is in session. Minutes of the meeting held on Tuesday, January 30th, 2024 to be confirmed. Honourable Member St. Joseph.
Speaker, I beg to move that the cited minutes be confirmed.
The question is that the aforementioned minutes be confirmed. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. The aforementioned minutes are confirmed.
Announcements by Your Honour this week.
I'm in receipt of a message from the Honourable, the Senate, to the Honourable, the House of Assembly. The Honourable, the Senate has the honour to inform the Honourable, the House of Assembly that at a sitting on Wednesday, 31st of January 2024, the Debt, Natural Disaster and Pandemic Deferment of Payments Miscellaneous Provisions Bill 2023 was amended in the terms as cited below. In Clause 1, the word 2023 was deleted and the word 2024 substituted therefore. In the Schedule Enactment 1 External Loan Act, Cap 94D, Column 2, Section 10.9, the second definition of CCRIF was deleted. And in the subsequent paragraph, it begins CCRIF policy, the word maybe was deleted and the words may be was substituted therefore. In the Schedule Enactment 2, Guarantee of Loans Companies Act, Cap 96, Column 2, Section 8.9, the second definition of CCRIF was deleted. And in the subsequent paragraph, which begins CCRIF policy, the word maybe was deleted and the words may be was substituted therefore. In the Schedule Enactment 3, Local Loans Act, Cap 98, Column 2, Section 17A.9, the second definition of CCRIF was deleted, and in the subsequent paragraph which begins CCRIF policy, the word may be was deleted and the words may be was substituted therefore. In the Schedule Enactment 4, Special Loans Act, Cap 105, Column 2, Section 5, Subsection 9, the second definition of CCRIF was deleted, and in the subsequent paragraph which begins CCRIF policy, the word maybe was deleted, and the words may be was substituted therefore. And the Honourable the Senate transmits the amended bill to the Honourable the House of Assembly, inviting concurrence in the amendments to the bill. dated 7th day of February 2024, signed the President.
Messages from Her Excellency, the President.
I am in receipt of a message from Her Excellency the President to the Honorable the House of Assembly. Her Excellency the President wishes to inform the Honorable the House of Assembly that Mr. Ralph Anthony Thorne, SC MP, has advised and submitted a letter to her dated 9th February 2024, stating that as the duly elected Member of Parliament for the constituency of Christchurch South in the general election held on the 19th January 2022, he wishes to sit in opposition to the government in the Honourable the House of Assembly. Her Excellency further wishes to inform the Honourable the House of Assembly that, in accordance with the provisions of Section 74 of the Constitution, she has appointed Mr. Ralph Anthony Thorne, SC MP, as Leader of the Opposition with effect from 12 February 2024, signed President.
Petitions, papers.
Honourable Member for St. Joseph.
Mr. Speaker, I am commanded to lay the 2021 Population and Housing Census Report, and then further commanded to lay the 2022 Barbados Economic and Social Report.
Government notices.
Honourable Member for St. Joseph.
Mr. Speaker, I beg to give notice of a resolution to approve, in accordance with Section 5 of the Crown Lands Vesting and Disposal Act, Chapter 225 of the Laws of Barbados, the vesting in the National Housing Corporation of 2 parcels of land situated at Castle Grant Plantation in the parish of St. Joseph in this island, more particularly described in the schedules thereto for a public purpose, namely for housing development.
Private members' notices, notices of questions, reports from select committees, first readings of bills, statements by ministers, congratulatory and/or obituary speeches, personal explanations, motions for leave of absence, oral replies to questions, notices of motions for the adjournment of the House on matters of urgent public importance, orders of the day.
Honourable Member for St. Joseph.
Mr. Speaker, I beg to move the suspension of standing orders 6, 16, 18, 20, 42, 5, 43, and 44 for the remainder of the day's sitting.
The question is that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. The aforementioned standing orders are hereby suspended for the remainder of the day's sitting.
Government business, sir.
Government business is the order of the day.
Order number 7. In the name of the Honourable Minister of Labour, Social Security and the Third Sector, to move the second reading of the Labour Clauses Concessions Bill 2024.
Honourable Member for St. Peter.
Thank you very much, Mr. Speaker. I rise this morning to introduce a bill that speaks fundamentally to protecting workers and protecting the ordinary people of Barbados. I'm happy to have the opportunity to do that, particularly in the environment within which we exist today and the developments we see taking place around us. Before I go any further, Mr. Speaker, I think I should acknowledge the presence of the team that works with me in the Ministry of Labour and the Labour Department. And they are here, and what we are going to be debating today is a result of the hard work of these ladies and gentlemen, public officers in this country who have dedicated their time and their efforts to the improvement of the lot of workers in this country. I also need to acknowledge the presence of some folk who I know pretty well. They're from an industry that I spent a significant portion, actually about half of my life, in. Members of the hotel division of the Barbados Workers Union. And they too have been instrumental in allowing us to reach where we are today. And as a matter of fact, Mr. Speaker, I think Welser was going to say it a little bit later. I ought to say at this point that over the past 3 to 4 years, I have become clear in my mind about the role of 3 of my predecessors as members of Parliament, members of this Honourable House. I have become very appreciative of the work of the Right Excellent Sir Frank Leslie Walcott, who represented the constituency that I now have the honor to represent, and who did that while being General Secretary of the Barbados Workers Union. I also have come to appreciate more fulsomely the work of JTC Ramsey. JTC Ramsey also represented the constituency that I have the honor to represent, and while doing that, was trustee of the Barbados Workers Union. As a matter of fact, he was the first trustee of the Barbados Workers Union. And I also have a fuller appreciation of the work and the contribution of Sir K.N.R. Husbands, both one of my predecessors as Member of Parliament for St. Peter, also your predecessor, Mr. Speaker, as the first Black Speaker of this Honourable Chamber, who was Assistant General Secretary of the Barbados Workers Union while Member of Parliament for the constituency that I now have the honor to represent. And so, Mr. Speaker, I am very clear in my mind when I feel the influence of the Barbados Workers Union and the influence of the General Secretary of the Barbados Workers Union in crafting the policies of this Barbados Labour Party government. The bill that we debate today is a bill that speaks to conditions that are applicable to concessions that are granted to employers in this country. I am happy to lead off the debate of this bill. But in a sense, Mr. Speaker, there is a little bit of sadness. Sadness because the labor clauses, public contracts, convention, and recommendation discussed and adopted by the International Labour Organization in 1949, which formed the basis for the Labor Clauses Public Contracts Act of 1952, came out of worker dissatisfaction, worker struggle of the 1930s, that we in Barbados in 2024 have to bring this legislation to this Honourable Chamber. Makes me a little bit sad because I am sure that the founder of our party would not expect that in 2024 we'll be debating a bill which is principally the bill that he piloted and had passed in this honorable chamber in 1952. The essence of this bill before us, Mr. Speaker, the essence of the 1952 Public Contracts, Labor Clauses Public Contracts Act, the essence of these legislation and proposed legislation is that where the taxpayers' money is involved, then those who benefit must treat to the taxpayers who work for them at some minimum standard, at least at some minimum standard. In other words, an employing entity should not be gaining any advantage over some other employing entity by not meeting at least some minimum standard for the treatment of their workers. And what this bill, this proposed legislation seeks to do is to ensure that those who benefit from the public purse are held to some standard. Mr. Speaker, the principle, like I said, is not new. It is a principle that has been applied since 1952 in this country. It is a principle that we have embraced as a country for over 70 years. We have embraced this principle not because it was foisted on us by an international agency. We've embraced this principle because we have experienced the struggle of workers. We have experienced in this country from as far back as 1675, the struggle of workers in St. Peter to free themselves and to improve their lot in life. We have had the struggles throughout 1816, the struggle of workers, the 1930s, the struggle of workers. We understand the struggle of workers. This party in government understands the struggle of workers to improve their lot. And so, Mr. Speaker, we are able to bring this bill to this honorable chamber because it is the right thing to do. We bring this to this chamber because it is the right thing to do for the workers of this country. We bring this bill to this chamber because it is the right thing to do for the economy of this country. We've had, just from the Labor Department perspective, a number of complaints made to the Labor Department. As you can imagine, on a daily basis, there are calls, there are emails, there are texts, and there are visits to the Labor Department. We have received hundreds of complaints for the type of treatment some of our workers have been experiencing in various sectors. We have had many complaints with regard particularly to the hotel sector. Now, Mr. Speaker, this bill is not a hotel sector bill. This bill is a framework piece of legislation that allows us, as does the Labor Clauses Public Contracts Act, this bill will allow us to shape the minimum terms and conditions of work for those businesses operating in sectors that receive concessions. And that would include sectors like those sectors that form the tourism industry. The hotel sector is one such sector. But I introduce the matter of complaints in the hotel sector to indicate to us and to help us to understand how we've gotten to this point. Some of those complaints that we received included matters that related to contracts, short-term contracts, the rolling over of these contracts, the use of the 6-week provision in the Employment Rights Act to allow employing organizations and the employers that they represent to almost, as it were, Mr. Speaker, disenfranchise workers. And when I say disenfranchise, allow me to be clear as to what I mean. When I say disenfranchise, I'm speaking to the fact that a worker with a 3-month contract, a worker with a 6-month contract, is not able to go anywhere to get any kind of credit. So if your stove breaks down and you need to get a stove on hire purchase, there is no entity that does hire purchase in this country that will take a 3-month contract as any security for the repayment or the payment of the installments. There is no financial institution that will grant a mortgage, or far less a mortgage, a short-term loan based on such a short-term contract. We also had complaints about conditions in staff quarters. Now, Mr. Speaker, I really don't want to dwell on some of these things because I have purged myself of not the anger, but let me coin a phrase, the upsettedness that
I remember there's a new English word.
I don't even know if it is English, but it sounds so. But Mr. Speaker, sometimes when you hear the reflections and the experiences of workers, it can cause you to be upset. But I made the decision, and I asked the Lord to help me before I came in here, and while I was in here sitting down, not to allow myself to, as my predecessor, my immediate past predecessor, as Member of Parliament for St. Peter, one who I love dearly, I tried to purge myself of that demon. But when you hear that there are no staff quarters, no places to eat lunch, sometimes no chairs to sit down in, these things can cause you to get upset. And that is the reason why I say that there's a bit of sadness bringing this bill to this honorable chamber in 2024. There are matters related to service charge, matters related to tips. The honorable member for St. Michael West Central did significant work, and I'm sure that he will speak to some of the details as he makes his contribution to this debate. But Mr. Speaker, in the discussions that were held with the hotel sector between September of 2023 and December of 2023, it became very, very clear. The honorable member for Christchurch East would say, well, I'm not going to say that because it may not be politically correct with respect to persons with disabilities, but even persons who may not be able to see properly, may have affected sight, could see that there was need to go beyond the sitting down, discussing, talking, and not making progress. And so, Mr. Speaker, we have come to this place today to ensure that as a government that has the responsibility to protect a country, a government that has a responsibility to represent those who are the most vulnerable in the country, That is the standard by which governance is measured. If we were all equal, then there would be no need for government. We will exchange among ourselves as equals. Government exists to ensure that those who are in the minority, those who are weaker, are protected. And so as a government, we have, recognizing that there have been significant complaints, and as we consulted with our partners, have made the decision to bring this bill before this House. I have been asked in our consultations if the complaints have been so pervasive that we need this legislation. Mr. Speaker, a question like that offends me. It offends me because there is implied in the question that a lot of workers have to feel pain before a government should act. That, as far as this minister responsible for labor is concerned, is offensive. We will not wait for all of the thousands of workers to complain before we act. Every worker in this country is a human being. Every worker in this country is as much a human being as every investor in this country. Every worker in this country is deserving of the same protections as every investor in this country. While we are the Barbados Labour Party in government, we recognize that we have a responsibility to the entire country. That entire country includes the workers of this country. Now, while we received complaints from the workers, I have to tell you, Mr. Speaker, that the decent businesses in this country are also complaining. Do you know, Mr. Speaker, I may have shared it here, we set last year minimum rates of pay and minimum conditions of work in the construction and road building sector. Again, a process we took, a decision we made, an exercise we engaged in because of the work, the advocacy of the Barbados Workers' Union. So, Mr. Speaker, I have to tell you that the Barbados Workers' Union found an ally in probably one of the few construction companies in this country that treats its workers as employees and who joined hand in hand with the Barbados Workers' Union to get those rates of pay and conditions of work established. Decent companies will join with the labor movement in this effort to set minimum standards of rates of pay and conditions of work. Mr. Speaker, when we established for the first time in Barbados a national minimum wage and a sectoral wage for security officers, it was as a result of the advocacy and the push from the Barbados Workers' Union. But I will tell you, Mr. Speaker, that the Barbados Workers' Union found an ally in a company that recognized it was being disadvantaged because there were some rogues out there. who were treating to their workers at a level that did not reflect a respect for their basic humanity. Decent employers in this country are standing hand in hand with the Barbados Workers Union in wanting to see legislation like the bill that we are debating in this honorable chamber today. This Barbados Labour Party in government will not renege on its responsibility, on its obligation to continue the work of our founders in uplifting the workers of this country. What we are about, Mr. Speaker, is protecting workers, protecting the ordinary people of Barbados. If we do not intervene, there will be a race to the bottom. This Barbados Labour Party, Mr. Speaker, and this minister responsible for labor, not in that. We are not going to be participant in a race to the bottom. We are happy that the Barbados Workers Union has been driving in this effort, and we are buoyed by the fact that decent employers are on board in this exercise. We are protecting our workers. We are protecting the ordinary people of this country. It's become very clear to us, Mr. Speaker, that the practice of industrial relations, as we have known it for quite some time, is changing. And I have, I think, a privilege, and I thank the Lord for it. I have the privilege of having, for some relatively significant portion of my life, been involved in industrial relations matters. I had the opportunity really to sit to some degree on both sides of the table. I've sat across the table from unions. I have been cursed by them. I have had a dear friend of mine who remains dear to my heart to this day, who was my shop steward and who led workers not to work because of a mistake that I made as an employer. So I've been on the receiving end of the wrath of trade unions. I've also had the good privilege of, after that, acting, in my words, as a shop steward to represent workers. I mention that not to say anything other than to say that I think I come to this office understanding the dynamics that are unfolding before us in the industrial relations space. There used to be a time when a gentleman's agreement was a gentleman's agreement. Those days seem to be retreating, not because of the need for gender equality, and so there could be ladies' agreements as well. And I'm not saying that because the General Secretary is the first female General Secretary, but trust has been eroded over the years. And whereas parties could take each other at their word, that is now not as often the case as it used to be. We in Barbados, Mr. Speaker, are becoming victim to some industrial relations practices that are not our own. You may want to say that they have been imported, but they're not our own. You may want to say they are foreign to us. What I can tell you is that they're not the industrial relations practices that I have been familiar with over the years. And so when we get to a point where trust begins to break, where the treatment of our workers appears to be in reverse, then we know that it is time for our government to act. Government has decided, based on a principle, like I said, that has existed since the late 1940s and the early 1950s, that employing entities in this country must, if they're going to benefit from the taxpayers of this country, must treat to those taxpayers in a way that we would consider decent, fair, reasonable. We're not asking for bells and whistles. You know, minimum standards, minimum rates, minimum conditions don't speak to bonuses, don't speak to overseas trips. We're talking about basic rates of wages, pay rates, basic conditions of work. And there is absolutely no reason, Mr. Speaker, and I am at a loss when I try to understand some of the noise in the public space. And the reason why I'm taking my time in going through this, the reason why I'm repeating myself from time to time, is because I realize that there are two categories of persons. There is a small group of persons who are seeking political relevance, who are seeking to distort narratives, who are interested in their own political futures. There is another group, a much larger group of innocents who are the victim of misinformation. Mr. Speaker, my intervention and my leading of this debate this morning is for that much larger group. I am not the traditional politician, and I have very little time for the misfits, the ones who are interested in their ego, the ones who are seeking relevance. I don't really have no time for them. The people in St. Peter did not elect me to engage too much with them. I am speaking to those who want to know truth, those who are interested in fairness and in reasonableness, and who want to understand genuinely what it is that we're doing in this place today. We focused in 1952 on employers who were in receipt of public contracts. Public contracts. In 2024, we are completing the cycle. Now, what do I mean by completing the cycle? The convention to which I referred, the Convention of 1949, Convention 94, spoke to public contracts. Government purchases items for school meals. Government contracts businesses to build buildings, to pave roads. Government is engaging a supplier. Government is paying that supplier for either a good or service that is rendered to government, meaning the people of the country. The recommendation that accompanied the convention, also adopted in 1949, spoke to subsidies and utilities. A clear recognition, Mr. Speaker, that there are employing entities that enjoy benefits from the government, but are not engaged in a relationship where there is a provision of a good or service and a consideration given, a payment given by government to the entity. A subsidy is when a government, chosen by the people, decides to assist a business or a sector and gives to that business or sector certain funds to allow them to get over a hump, to be more competitive, to assist them in some way. Subsidies. Utilities, but everybody got to pay the light bill. You don't sign no contract. When the bill comes, you pay it. Sometimes the telephone bill comes, and if it don't get paid, you're trying to WhatsApp, and you realize that the message is not going through. That is not procurement in terms of public contract. But the International Industrial Relations Fraternity recognized that there were these additional areas where employing entities are benefiting outside of public contracts. In 2024, Mr. Speaker, we, as we treat the subsidies, have done it in a more elegant way. Rather than taking taxes and then giving those taxes back as subsidies, we say to some organizations, we say to some sectors, you hold on to the tax that you would ordinarily pay to support healthcare in the country, or to support the building of roads in the country, or to support education in the country. You don't pay the taxes, you hold on to those. Rather than us taking and giving back, you hold on. Concessions are subsidies, more elegantly and efficiently administered. And so all we are doing is completing the cycle envisaged over 70 years ago with respect to employing organizations and their responsibility to the workers they're employing. We, Mr. Speaker, are protecting workers. We are protecting the ordinary people of Barbados. You know, I joined the Barbados Labour Party because I understood that the Barbados Labour Party started through championing the rights of workers, and throughout its existence has been championing the rights of workers. The photograph that stands out in my mind is the photograph of the now Right Excellent Sir Grantley Herbert Adams in the cane field, with ordinary workers listening to those workers and responding to those workers. This is the Barbados Labour Party in office. I have already said that 3 of my predecessors were active in the labor movement, and I am proud to stand on the shoulders of those who've gone before me in championing the rights of workers in this country. That is the Barbados Labour Party legacy. The Barbados Labour Party legacy is about protecting workers. It is about protecting the ordinary people of this country. We remember Sir Grantley in 1937, at the beginning of a law practice that could be lucrative, representing a man who the established class saw as a troublemaker. If you want to earn a lot of money, you do not antagonize those who have a lot of money. That is the reason why I don't have any fear in doing what I do, because I don't want to have a lot of money. But that is the man who started this movement. He started the Barbados Labour Party, the Progressive League at the time. 1 year later, 1938, he started the Barbados Workers' Union, 1941. He ensured that all adults, ordinary people, could vote, 1951. He passed the Labor Clauses Public Contracts Act, 1952. That is the legacy upon which we stand. That is the framework upon which the labor clauses concessions bill is framed. Mr. Speaker, one of our leaders in the past said that Barbadians have short memories, and I have not done any survey to work out if that is true or not. I don't know if a billion consultants, the business once run by the Honourable Member for Christchurch East Central, sorry. I don't know if any research has been done. But I don't like taking chances either. And so I want to remind you, Mr. Speaker, I want to remind this Honourable Chamber, I want to remind the country that since this Barbados Labour Party came to office in 2018, we have given 2 pay increases to the public officers of this country. Mr. Speaker, since coming into office, we have appointed 3,388 public officers in this country. That includes 422 officers who lodged cases with the President or Head of State, Her Excellency, and those have been adjudicated. 3,388. Since we came into office, Mr. Speaker, we established the position of Customs Officer 4. And 138 officers were appointed. And this also a response to the labor movement, including the Barbados Workers' Union, who pushed for this. Since coming into office, Mr. Speaker, we have increased non-contributory pensions in this country. Since coming into office, we have enacted legislation to outlaw discrimination in the workplace in this country, protecting workers, protecting the ordinary people of Barbados. Since coming into office, this Barbados Labour Party government has enacted for the first time a national minimum wage. Do you know, Mr. Speaker, that the minimum wage for shop assistants was $6.25? And we set a national minimum wage at $8.50. And there were people in Barbados who said that all the businesses would shut down, that investors would not come, that we were going a step too far. This Labour Party is about making sure that ordinary people, the workers of this country, can at least eat, put a shirt or a dress or pants on themselves, and lay down and sleep half decently at least at night. We are about protecting workers. We are about protecting the ordinary people in this country. We have enacted, Mr. Speaker, since we came to office, regulations to support the Safety and Health at Work Act. And I must tell you that those regulations, and I'm telling you and I'm reminding those involved, these regulations include 2 things that I consider to have been a stain on this country. These regulations that we established as a government since coming to office include the provision of bathroom facilities for all workers, whether you're working alongside the road, in a cane ground, wherever you are. The employer has a responsibility to provide bathroom facilities. Now, that I have to say that so strongly in 2024 tells you where we were in the not too distant past. Those regulations also included the provision of rain protection gear and the entitlement of workers in fuel stations to annual medicals at no cost to the worker. This is the Barbados Labour Party that I'm a part of. This is the Barbados Labour Party that protects workers, that protects the ordinary people of this country. As a party in government since 2018, we've introduced case management to speed up the throughput of cases before the Employment Rights Tribunal. We've established a national workplace wellness policy. And again, Mr. Speaker, I have to say to you that our establishing of a national workplace wellness policy was at the urging of the Barbados Workers Union. I came to office, took up the responsibility, and one of the first things that was placed before me was a body of work commissioned and executed by the Barbados Workers Union. And we moved swiftly, working with them to establish a national workplace wellness policy. And I'm pleased to say that work continues at pretty good clip, pandemic notwithstanding, on implementing, actually making it real to the workers of this country. As a government, we have started the process of revitalizing the national insurance scheme. Again, protecting workers, protecting the ordinary people of Barbados. We've restarted the overseas program in the United States of America. And we have quite a number of hospitality workers in the US as we speak. As a matter of fact, I should say to you that the response to the establishment of that program was an indication that all was not well in the tourism sector in this country. Because people who I know, having spent half of my life in the industry, happy, had reached the point where they were prepared to go into places where they knew there was racism. But they thought they had to get away. They still loved the industry, but they thought they needed to get away. These things, Mr. Speaker, weigh heavily on persons who have feelings, who are sensitive to human beings. These things drive governments to act in defense of workers. Mr. Speaker, I indicated earlier that the bill before us today is framework legislation. And while it can trace its genesis to some degree to our discussions with respect to the hotel sector, this bill is not a hotel bill. This bill is not a tourism bill. This bill is not a anybody bill. This bill is a framework bill. This bill, Mr. Speaker, is very similar, based on the same principles, similar in structure, similar in content, to the Labor Causes Public Contracts Act. And so when we established rates for construction in 2023, we identified a sector that needed to be addressed, and we addressed that sector within the context of the framework legislation. That framework legislation allows government to proceed to address minimum rates of pay and minimum conditions of work in a sector. All of that to say, Mr. Speaker, that the legislation will not bind anybody to do anything unless the provisions of the legislation are adhered to. And I will speak to that in just a moment. So there are no rates of pay in this bill. There are no conditions of work in this bill except conditions that are already established by law. So there is nothing in this bill that causes any consternation or that should cause any consternation to any employer, because those things that are mandated by this bill include the Employment Rights Act. That is law. It probably didn't even have to be here, but I'll tell you how it got here. The Employment Prevention of Discrimination Act. That is law. Maybe it didn't need to be here. It is law. The Employment Sexual Harassment Prevention Act. Again, legislation that already exists on our statute books. Labor Clauses Public Contracts Act, a piece of legislation that is older than most of us. The Labor Department Act, a piece of legislation that already exists. The Protection of Wages Act, a piece of legislation that already exists. And Mr. Speaker, it is one that we are in the advanced stages of amending. The Chief Labor Officer and the Deputy Chief Labor Officer have advised me that before the end of the week, the draft that we have received from the Chief Parliamentary Counsel's office will be shared with our partners to elicit their comments on the bill. But Mr. Speaker, just let me speak tangentially to this whole matter of protecting workers and why a government has from time to time in 2024 to come to this place and spend time protecting workers in a situation where you feel that decency should prevail. You know why we are only now sending the protection of wages bill to the partners? We had to stop after receiving a report that an employer in this country in 2023, the third decade of the 21st century, paid their employee or former employee over $200 in coins. Mr. Speaker, for those who ask if these complaints are so pervasive that a government needs to come to Parliament to pass legislation, I say to them, one worker receiving $250 in coins is, in my mind, reprehensible enough that a government has to act. A government is constrained to act. I am not waiting, Mr. Speaker. This government, this Barbados Labour Party government, we are not waiting for the second person to get paid $200 in coins. We will not do it. And if people feel that we are coming here too regular to protect workers, that is what we were elected to do. That is the reason why we joined the Barbados Labour Party. We joined the Barbados Labour Party because we are about protecting workers. And that is why we are staying with the Barbados Labour Party. Now, Mr. Speaker, there's been some consultation that has taken place, which is what we always do when we are proposing legislation. The idea that we would take this step was birthed in the discussions, we call them colloquia, that we had with government, the Barbados Hotel and Tourism Association, and the Barbados Workers Union. And as the discussions proceeded, there was a view that they were not going anywhere, that we would not get an agreement on basic conditions of work. Now, I consider myself an optimist. I don't get involved in a lot of negativity, and I don't really like negative people around me anyhow. And while the Barbados Workers Union, through its General Secretary, started to agitate for a legislating, for a using of an existing principle to establish these minimum conditions and minimum rates of pay, the Honourable Member for St. Michael, West Central, and myself continued on in the hope that we would not have had to go in this direction. Now, I know that I'm not perfect. I know that I'm sometimes wrong. Those who work with me will tell you that even though I say so, sometimes they say I get on as very perfect. But I really did not want to have to say to the General Secretary of the Barbados Workers Union that the General Secretary was right. I don't even know if I have said that up to now. But I have come to the view that this is a step, and the Honourable Member for St. Michael West Central has also come to the view that we have really no choice. The environment within which we are operating leaves us no choice. If I were going to use the King James, I would have said it constrains us, just like the love of Christ does. And so, in those discussions, the idea that we would be going in this direction was raised. In the social partnership meeting of December of 2023, there was a discussion about the need for it. We addressed the idea that there was some level of fear about it, and we believe that we allayed some of those fears at that time. We invited comment from the Barbados Workers Union on the bill. We understood, Mr. Speaker, and I need to make this very clear, we understood and still understand that this bill is about concessions. Concessions are granted to private entities. Concessions are granted to private entities. And so we consulted with the union that represents workers in private entities. We also consulted with the Barbados Employers Confederation, and we invited them to submit comments. I had a meeting with them myself. We went through the bill. We went through some of the matters that they wanted clarity on. We had that meeting. We also addressed the concerns of the Barbados Private Sector Association. We met with them. We addressed their concerns. We met then with the larger group. Now, allow me to say to you that in consultation, you approach the umbrella organizations. The understanding is that the umbrella organizations will consult with their members. Even though we'd already taken and had engagement with the umbrella organizations, we agreed just yesterday to meet with the wider body. I don't know, maybe there were about 150 persons present at the meeting yesterday. And issue by issue that was raised in that meeting, we addressed them all. And I can say to you that the feedback coming out of that meeting, we ended the meeting maybe just before 2, or just after 2, I think. I left the Lloyd Erskine Sandyford Center around 4. All of that time was spent continuing the engagement with employers. And I can say to you, Mr. Speaker, that those with whom I engaged, those with whom a member from the other place who has a ministerial responsibility for commerce engage, those with whom the Honourable Member for St. Joseph engage, they all are of the view that what they're considered to be their fears have been addressed by us in our interaction with them. And I'm happy, Mr. Speaker, to be able to say to you that coming out of that meeting, not just an allaying of fears, but from some quarters, an embracing of the direction in which this country and this government is going. Mr. Speaker, that embrace comes out of a recognition that decent people do the right thing, but that rogues will undermine decent businesses if they are allowed to do the wrong thing. This Barbados Labour Party in government, not about allowing rogues to do the wrong thing. We will not be participant in the race to the bottom. We are about protecting workers. We are about protecting the ordinary people of Barbados. Now, out of the, and I think I need to quickly share that out of the consultation with the private sector, because that is where most of the response came in terms of public response. They've asked that the incentive legislation be listed in this bill. And at Schedule 1, you will see, in response to their urging, a listing of 5 pieces of legislation. The first schedule is titled Concessions Enactments. We responded to that one. We had in the draft included incorrectly tax refunds. Now that should never have been in. And Mr. Speaker, I'm saying this, and I say this almost every time I speak in this honorable chamber. I am happy to be part of a government that recognizes when it has made a mistake and is woman and man enough to make the correction. The draft that we sent for discussion included the term tax refund. Should not have been there, or error. And we acknowledge that, and we've changed that, because a tax refund is somebody's property. You can't withhold a tax refund for any reason. So that should not have been there in the first place. So that was deleted from the definition of concession. We also agreed that the mention of NIS under taxes should not have been there, and that was taken out. Those appeared in the draft, but those were taken out. So we responded. We strengthened the appeals process. If in the setting of minimum rates of wages and conditions of work, there is a dispute, that dispute will be referred by the Chief Labor Officer to the Employment Rights Tribunal. If at the point of revocation or suspension by the minister responsible, that the company or the employing organization that feels aggrieved has also further recourse. And so I'll speak to that as I go through briefly. But we strengthen the appeal process in response to the messages, the information, the concerns that we received from our partners. We did not use the minimum wage board in this exercise because our immediate concern, Mr. Speaker, is protection for the taxpayers of this country when the taxpayers' money is being used to benefit employing entities in this country. And we already have the framework, as I said, since 1952. And we disagreed with the BEC on that point, but I do not think that that was any a red line, so to speak, as we would say in negotiation terms. Now, the bill is a very short bill, while very important as a bill. Section 2 speaks to the definitions. There's the Barbados Revenue Appeals Tribunal. Concessions, I spoke to that before, exemption, waiver, remit of a tax. The status of an employer as having become defined actually as an approved entity or an approved product. Employee is also defined, employer is also defined, the Employment Rights Tribunal is defined, and tax, which I spoke to earlier, import duty, consumption tax, income tax, any other tax, duty, or impost. Then Section 3, Mr. Speaker, speaks to labor clauses. Section 3 refers to the second schedule. It essentially, beside referring to the second schedule, also gives the minister who is responsible, who is named in the second schedule, the authority to act. It gives the chief labor officer, who is mentioned in the second schedule, authority to act. And it gives the provision that I indicated earlier for dispute resolution at the point of setting rates or minimum conditions. Now, if we go to Schedule 2, the second schedule, if there are no established rates already in a sector or in an industry, then there is a process by which those rates of pay and conditions of work are to be established. That process is a process of consultation. And this consultation, Mr. Speaker, we know because we have used it before. We used it last year with respect to the setting of minimum rates of pay and conditions of work in the construction sector. We were able to sit with the representatives of workers and workers. We sat with the representatives of employers and employers, and the chief labor officer worked through with them through a process of consultation, of hearing back and forth until they arrived at rates of pay and conditions of work that could be established. That process is already known to the Ministry of Labor. It is known to the organizations that represent employers, and it is known to the labor movement. And so that is the process. There is provision, like I said, even if all of that has happened and a business is in disagreement with the majority as represented by the umbrella organizations, there is still provision for that employer to make representation before the Employment Rights Tribunal and have their case heard. The bill provides that if you get to a point where the relevant minister, that minister meaning the minister who is responsible for the enactment that grants the concession, if things get to the point where that minister is in a position where the minister believes he or she has to suspend or revoke the concessions. And the reason why I phrase it like that is because The bill is very clear that the minister responsible for the concession may suspend or revoke. There is no insistence that it happens. We have left in this bill the understanding that there may be situations where the minister responsible will need to use a discretion. But if the minister responsible is at the point where he has to or she has to revoke or suspend the concessions, then if there is a situation where the business, the employing organization feels aggrieved, that employer has the right to use an appeal to the Barbados Revenue Appeals Tribunal, an eminent appeals tribunal headed currently by a former Chief Justice of this country. And that entity can appeal to the tribunal to have a hearing on the matter. And of course, you know, as an eminent legal practitioner yourself, that there's the Administrative Justice Act, which can also be used. And so, Mr. Speaker, this bill allows us to continue the process of protecting our workers. The bill allows for regulations to be made. Any regulations that are going to be made under this bill will also have the full participation of the partners, the social partners, the employers, and the labor movement. These regulations will be made to give better functioning, more effective functioning to the legislation. But it is our intention, Mr. Speaker, to ensure that in a 2024 Barbados, the workers of this country can wake up and go to work, recognizing and understanding that there is a minimum standard below which they cannot go in terms of their treatment. There has to be a minimum standard. A country is judged by how it protects the vulnerable in its midst. We cannot, Mr. Speaker, in 2024, allow for a situation where those who benefit from the taxpayers of this country are allowed to go below a minimum in the treatment of their workers. We cannot allow in a 2024 Barbados a situation where decent employers are made to suffer because they're being undercut and undermined by those who are going below what is decent with respect to the treatment of their workers. Mr. Speaker, we are about social justice. Social justice includes worker justice. Social justice includes justice for all of the vulnerable in this society. All those who are marginalized or feel marginalized. This is what we have been called to office to do. This bill represents the philosophy of the Barbados Labour Party. This bill represents the role and function of this Barbados Labour Party. This bill represents a continuation of the work of this Barbados Labour Party as it continues to protect workers, as it continues to protect the ordinary people of this country. And with those words, Mr. Speaker, I beg that this bill be read a second time.
All member for Christchurch South.
I'm obliged to you, sir. Your Honor, from my location, tradition binds me to announce to you that from this day onwards, I speak in opposition to the government. And in so doing, I promise you, Your Honor, that there will be a quality of parliamentary conduct that will meet the standards of this House. And indeed, there will be a quality of parliamentary conduct that will accord with the standing orders of this House. And so I come to you today in that new capacity, and I feel honored to do so. Not so much that I do it in opposition to the government, but that more importantly, I express my voice on behalf of the people of Barbados in this chamber. Now today, the Honourable Member for St. Peter announces that he brings legislation here, and I will read it. I will read the long title of that legislation. The short title is the Labour Clauses Concessions Act 2024. The long title says, an act to make provision for the conditions applicable to concessions granted to employers. Admittedly, this is a curious piece of legislation. Curious not because of its sociological and historical context, but curious because it presents some legal difficulty. And if he were to take advice from government's principal legal advisor, and if that advice were to be correct, he may wish to revisit this legislation not for its noble sociological purpose, I heard him, but for its legality. I speak not only as a parliamentarian, but I speak as a lawyer. And I speak as a lawyer interested in justice. And yet I will commend the Honourable Member for St. Peter for expressing himself to be in defense of the workers of this country and to be in defense of the unions of this country, and that is noble. Except, and I repeat, he may wish to revisit those who must remain available to give him advice and to give him good legal advice. This bill today stands on shaky legal ground, and I don't wish him to become nervous about that. He speaks as a minister with a background in accounting. I speak as a parliamentarian with a legal background. So if he does not consider me presumptuous, I will offer him some little legal advice. Not because I think I'm right, but because I do have a little experience in these matters. And everybody has a right to be wrong. And I'm one of those persons who exercises that right. I have the right to be wrong. But I want my contribution in here today, Your Honor, to dwell on matters of law, because this concerns a relationship, not only a historical relationship between capital and labor, but in terms of law, it involves a very difficult and curious relationship between two ministers. I assume a minister of tourism and a minister of labor. and I wish to explain to the public in plain terms that my understanding of this bill today is that if a Minister of Labor believes that an employer has acted against the interests of a worker, that he may recommend to a Minister of Tourism who deals with concessions granted to employers. He may report to him as such and recommend, and I use this word deliberately, recommend punitive action against that employer. And that at the end of that, those two goodly ministers will have the power to remove concessions. Presumably, if you're removing concessions, they would have been granted to that person, and I will come to the constitutionality of that very shortly. But that is the curious relationship, that is the difficult relationship that this legislation purports to deal with today. Your Honor, I say in your hearing again to the Minister, this is not a statement against workers' rights, because I believe we're all unanimous that it is a responsibility of a government to protect workers' rights and to acknowledge the history of a country in which there have always been tensions between capital and labor. That's the history of this country. That historical tension that has existed between capital and labor, from settlement through bondage, through emancipation and post-emancipation. And we all know that those tensions survived emancipation, those tensions survived the riots even in 1937. And I believe the Minister will agree with me that those tensions exist today. And we all remain unanimous in our efforts to resolve those tensions. And I think the Honourable Minister, his trust as a very activist Minister of Labour, and I listened to him very carefully, his trust as an activist minister is to continue that mediation between capital and labor that seeks to resolve those tensions, that seeks to create an industrial environment that is harmonious. So that I don't mind commending the minister for his effort to mediate a relationship that is tense, historically tense. And the fact that he has brought this bill here today, sir, is evidence that those tensions survive, those tensions exist today. But as I have told this government, and I tell this minister, through you, sir, it may be useful to take some legal advice on what is before the House today. What is before the House today, what this legislation promises to do is to deprive employers of property given to them by another minister. I want to say to this House, I want to say to this country, and to opine that a concession given may be in the nature of property. I think the Honourable Minister acknowledged and conceded that the original bill that comes to this House contains an error. That the Honourable Minister brought a bill here today which purported to confiscate tax refunds. That is property. And under the Constitution of this country, The state cannot, will not, must not confiscate the property of citizens of this country. You were strong, he was strong, Your Honor, on history. He was strong in sociology and social relations. But perhaps he will agree to defer to me on matters of law. And I say to this government, I say to this House, I say to the people of Barbados, that there's an acknowledgement today that the legislation was purporting to confiscate property from Barbadians, from Barbadian companies, from Barbadian employers. So we accept the concession that an error was made. And we accept that there's a withdrawal of the portion of the bill which had purported to be confiscated property, so-called tax refunds. Now, I believe there's other property that will survive, even after that amendment is made, even after that deletion is made. What is a tax concession? I asked the Honourable Minister, after consultation with his Attorney General, government's principal legal advisor, if a tax concession is not in the nature of property. I asked him that. And I asked his Attorney General the same thing. Now, you, sir, I always turn to you, and I remind you that it is always my pleasure to address you on matters of law. There is no rule that a speaker must be a lawyer, and therefore it is fortuitous that you are a speaker and you are a lawyer, and that when I address on matters of law, I know that I will have your full attention, and I know that I will have your expertise. And so I turn to you now, sir. What is the nature of a tax concession? Is it property or is it not property? And if it is property, just as a tax refund is, by their admission, property, what is the basis for its survival in this legislation? If you say that the tax refund is property and therefore you withdraw it from the legislation, Mr. Speaker, let us ask the same question in relation to a tax concession. Your Honor, within the law of property, there is a genus of property. I'm addressing you now, sir, and therefore you will hear technical language. And you and I will explain to the public afterwards. There is something called a shows in being. And for the sake of the public and for my colleagues on the other side who have forgotten their law, C-H-O-S-E, it's a French word meaning thing. And a thing, if it is a thing, it's property. And there are two categories of that thing. Shows is a French word, meaning thing. And we as lawyers adopt the French word in describing what is property. So we have a thing in being, a shows in being, a thing that exists. That is what we mean when we say a shows in being, a thing that exists. The other category, and that is property. You smile, Your Honor, because you smile in agreement. You love the law. And the other category are shows in action. Like a promise. I promised to give you my book. But you don't have it yet. When you have it, it becomes a shows in being. It is yours, it exists, you have it. But on the other hand, I may say to you, when I make the book, it becomes yours. And I will say it, and I could say to you, having made the book, I will deliver it to you on Sunday. And I make that a promise to you. And the law would describe that situation as a shows in action. It will take place. It will become yours. But the law says you can claim it. You can claim a promise of this thing. And if you claim the promise of this thing, and the law says that claim is validly made, it is a shows in action. In other words, its transfer has been effectively made to you. Although you can't touch it, Your Honor, its transfer is effective. It is yours. It doesn't exist within the property that is yours, but a promise made to you is effective in transferring that property to you. So that you have, Your Honor, a shows in being and a shows in action. I have gone through all of that to ask the question whether a tax concession promise to an employer, and in this event, a hotelier, is that concession, though not yet given, is it property? The Attorney General has returned to his seat, and I'm in no doubt that he will assist the Honourable Member for St. Peter, and that he will say to him at some point before the day ends whether a tax concession is in the nature of property. And if it is in the nature of property, he may want to indicate to him, that is to the Honourable Member for St. Peter, whether he may need to revisit this legislation. And as he did with the tax refund, which is definitely property, beg your pardon, sir, whether he may need to revisit the retention of a tax concession. But there are other difficulties. And let me pause, Your Honor, and remind you, and to remind this chamber, and to remind this country, that an insistence that law should be respected is not synonymous with a statement against the interests of workers. I have never met a politician who has spoken against the interests of workers. So please pardon me. It is not that we speak against the interests of workers. It is that we speak in defense of law in this country. The law that must regulate relations between all citizens. The law is important. Now, he, having taken that advice, may wish to take certain other advice. I think I did say, if I did not, let me hasten to say it, that under Section 16 of the Constitution of Barbados, it is unlawful for the state to deprive any person of his property. And if his Attorney General concedes further at some point today and tells him, look, Honourable Member, that shows in being or that shows in action may well be property. If he tells him that it is a shows in being or a shows in action, if he tells him that, but I want to suggest the Honourable Attorney General must affix some description to it, because it must mean something. If the government says to you, I am giving you a concession, what is that? Is it a promise made in nubibus. That's another technical term that we use, Your Honor. In the clouds, has no real existence, no real definition. Or is a tax concession? Can you insist on a tax concession? Government says, a minister says, I am giving you a concession, and he puts it in writing. What is that? What is that promise made to the employer? What is that promise made to the company? What is that promise made to the hotel? Is it a mere promise upon which he cannot sue? What has he done? What has the government done? I asked the minister in the hearing of his Attorney General to determine, before this legislation reaches the other place, whether a tax concession is to be considered property, or is it a mere promise that can be withdrawn? Because that is what this legislation purports to do today. This legislation purports to be withdrawing a promise that government has made. I ask the question again, is it a mere promise? Or is it a shows in action? Is it something upon which you can sue if you do not receive it? And I apologize to the Honourable Member for St. Peter, for whom this is all a very abstract disquisition. I apologize to him. Now, so that he may be trespassing on issues of constitutionality, he may be trespassing against Section 16 of the Constitution, and someone may tell him, in spite of his valiant efforts to defend workers in this country, that he is falling in violation of constitutional law. And the Constitution is still the supreme law of this country. And the Constitution of this country still determines the validity of all laws inferior to the Constitution. There are other difficulties presented by this legislation. I took good notes when the minister was speaking, and the culmination of his address was this. And I want your attentive ear, Your Honor. He said, and I quote, "The Honourable Member for St. Michael West Central and I continued on in the hope that we would not have had to go in this direction." And I took him to be saying that this bill today is the direction in which they had hoped not to go. And please, members, honourable members for St. Peter and St. Michael West Central, you do know that this is objective, that this is not personal. You do know that we are here to let ideas contend and to let the law reign supreme. And so I invite you again, please visit your Attorney General and get an opinion on these matters. But there was an apprehension that you would not have had to go in this direction. Why? Why the citizens of this country must now ask? Why did two ministers hope that they would not have had to go in the direction of bringing legislation in here today that gives a minister the power to punish? Because that is what it is. My parliamentary colleague from St. Peter may be intending honorably, hope that he would not have had to have gone in this direction, except that today is evidence that he has gone in this direction. Is it a direction that the Constitution of this country will condone? Is it a direction that the law and the rule of law will condone? I can't give the answer. Finally, I started to look at this yesterday evening and more fully this morning. But perhaps he will reply and he will say to us, what is it that caused him to apprehend that the direction was not going to be perhaps the ideal direction in which to go? I suggest to you, Your Honor, that doubt leaves us to conclude that perhaps there's an admission that there's trespass made against Section 16 of the Constitution of this country, which speaks in defense of the right of the citizen to maintain and retain his private property. But there's further difficulty in law. Again, I admire his passion on behalf of the workers whom he says he is defending. I invite him to lean and incline his ear to the same law that will protect those workers. If you're going to do something, please do it properly. Now, here's the other difficulty, and this one is particularly difficult, troublesome. This one is particularly troublesome, I beg your pardon. The first one, we admit, if it is property, just as with the tax refund that they concede is erroneous and remove, you decide today, honorable member, whether you're going to continue to tell employers in this country that you have the right, you have the discretion, and those are gentle words, that you have the power to deprive them of their property. And so I am going to remove myself from the word discretion and agree to use the word power. I visited that word and that concept on the last time my voice was heard in here. And I'm going to speak about it again. And I'm going to say, Mr. Speaker, that there must now be a trend in this country, a trend of legislation in which ministers within the four walls of legislation focus on their power, focus on the legislated right to punish. That is what is happening in Barbados. The legislated right to punish. If I, as minister, consider, if I deem you a rogue employer, I will punish you. If I consider that you are in breach of some labor law somewhere, I, as a minister, I am giving myself the right to punish under law. I challenge the right of any minister, and certainly under this legislation, to have the right to punish the citizens of this country. We have a court system, and a highly sophisticated court system. And when a minister assumes the power to punish, he is usurping judicial functions. The only body in this country that has the right to punish, apart from the superintendent of prisons who can flog people, are the courts. But if the honorable member for St. Peter wants to flog people in this country by way of removing a show's inaction, I say to him, that law is questionable. I will come to you, Your Honor, under the doctrine of separation of powers, and I never exclude the public. As I said, I come to you as a lawyer, and you and I speak equally on the law, but let us speak to the public by way of explanation. There's a doctrine called the separation of powers under the Constitution. And under the Constitution, say this all the time, and my colleagues are so bored, but I'm going to say it now to the public since I've bored them. The three bodies that constitute the state called Barbados, is the cabinet, which contains so many of you. So many of you. Such powerful people. A large body of persons called the cabinet. You constitute that constitutional body of great power. Great power. You're called ministers. And you have a lot of power. But under the Constitution, you have a specific role. And that role is to manage the day-to-day affairs, the executive affairs of this country. You've come here as parliamentarians, and Parliament is the other body that constitutes the state of Barbados. And the role and the function of Parliament under the Constitution is to pass laws for the peace, order, and good government of this country. So that you belong to two of those three constitutional bodies. One that manages the day-to-day affairs of this country, and the second one, this one that we sit in today. We're here to pass laws, and that's why the Honourable Member for St. Peter came here today. He came to pass law. Of course, my submission is that the validity of that law is subject to question, but I wouldn't repeat that. And there's a third body that constitutes the state. That's the court system, the judiciary. And it is only the judiciary that has the power to adjudicate on disputes, that has the power to determine whether there has been an infraction against the law. And apart from making that determination after adjudication, they have the right to punish. So any other actor within the state that tells you whether he's a member of the cabinet or a member of this August Assembly, if he tells you that he has some constitutional right to punish, he is speaking in offense against the law. He is speaking, Your Honor, against the doctrine of separation of powers. That is not his province. That is not his domain. He is usurping. And please, Honourable Member, this is not personal. Let ideas contend. Let us discourse on the law, and let us discourse on the law lawfully. And you will go to your Attorney General this afternoon, and he will opine as to whether what you have brought here today has legal validity. And I say to this chamber, I say to this country, in spite of the unanimous desire among all of us to protect the rights of workers, let us also protect this Constitution. And let us consider whether a Minister of Labour has the right to punish an employer. Let us consider that. My own legal opinion is that the Minister of Labour, by virtue of this legislation, is acting unlawfully. That he is assuming a power, a punitive power, where the Constitution does not allow it. A labor dispute is subject by law to the Employment Rights Tribunal and or the Supreme Court of this country. As departments within the constitutional judiciary, they hold the exclusive right and power to adjudicate and to punish. Your Honor, I wonder whether the minister under this act is not trespassing. My humble opinion, and he may well persuade me otherwise later. I've conceded that even I have the right to be wrong, and if I'm wrong, please tell me. But I believe I know the Constitution of this country. And beyond the Constitution, there's the political point that must be made that a government has to be wary of a public perception that it is becoming tyrannical, that it is assuming powers that really are unlawful, that it is assuming powers that it really ought not to have, that it is assuming powers that are excessive, that it is assuming powers of the judiciary, and that it is usurping judicial function. And that is my difficulty with this legislation, and that is not anti-worker. That is not anti-worker. It may be interpreted as being a statement in favor of hotels. It may well be interpreted as that. But in fairness, those of us who speak the truth recognize that all persons have rights. And as I've said before, I admire his zeal, I admire his passion in defense of workers. But I invite equal passion and equal zeal in relation to a defense of the Constitution of this country. Now, I made further notes. I did make further notes. But on the issue of usurpation of judicial function, there may be another difficulty created by this legislation. We are told that the minister, presumably he will go across to the Ministry of Tourism and say, my brother, I have made that determination, now you act. I don't know if they're in the same building, telephone call, I suppose. And he goes to the honorable member for St. Michael West Central and says, look, I have a bad behaved employer. I have a bad behaved hotelier down there in St. James. You gave him a concession? I did. Well, I want you to take it away. And the good and honorable member for St. Michael West Central, not having heard anything, not having heard any evidence, not having been privy to the transaction between the hotelier and his employee, having heard from his friend and colleague, and relying on the evidence given by his friend and colleague, telephone call, whatever. And he says, okay, you don't tell me no lies. I believe everything you tell me. So I am going to punish him with you. I'm going to punish that hotelier. And look, perhaps a few years ago, I had a run-in with him, so I'm glad we have him now. You laugh, but we all laugh. But what we are reflecting on here is that a minister of government should never sit in a judicial capacity. Politicians carry innate biases. And that's why you don't put a politician in the court as a judge. And that's why you don't put a politician to sit as chairman of the Employment Rights Tribunal. We come with innate biases. We know so many people. And so many people may have grudges against us and vice versa. And that's why we are disqualified from making judicial determinations. That is not our function. So that the situation must be fairly untidy when you ask a Minister of Labor to visit his friend, the Minister of Tourism, and bring a message and punish a hotelier. That is fairly untidy, Mr. Speaker. And I know that the Honourable Attorney General is taking very furious notes, and he will visit you today, this afternoon, and give you pertinent advice. Whether that relationship between two ministers, in the absence, I assume, of the offender, are you going to bring the hotelier there in front of you and make the determination, or does the Minister of Labor make the determination alone? both ministers are out of joint. Legally, of course, with what the law permits them to do. And then we hear that if the hotelier, employer, and we're dealing with hotels here, if we hear that the employer does not like the decision, he can appeal to some tribunal. If you don't like it, you go to the Barbados Revenue Appeals Tribunal. So the hotelier goes to that tribunal and begs that tribunal to return his deprived concession to him. In every appeal, there's a party called an appellant, that is the person who appeals, and there's a person called a respondent, the person against whom you appeal. We expect that the appellant will be the hotelier. But against whom is he appealing? Who is the respondent, Minister? Is it the Minister of Labor? Is it the Minister of Tourism, with whom the Minister of Labor would have acted in concert? Who is the respondent? You see, law includes order and systems and rules. So you can't be jumping all over the place unless you know who is your respondent. Now, if at that Revenue Appeals Tribunal, a minister, and I may be wrong, I have a right to be wrong, but I don't lose the right to speak and to ask questions. And these are questions to you today, Minister. Who is the respondent? Against whom is the aggrieved hotelier appealing? I ask again, is he appealing against the principal actor, being the Minister of Tourism, who deprived of the concession? Or is he appealing against the Minister of Labor, who made the decision? Or indeed, is it a joint decision to take away? We don't know. The legislation does not tell us. And the reason the legislation does not and cannot and will not tell us is because it is probably not a lawful transaction. It is probably not a lawful action that may be taken. And so I invite my friend, the Honourable Member for St. Peter, in concert, perhaps with a very receptive Minister of Tourism. All honourable men, and so are we, all honourable men. And being so honourable, they, in reply, will tell this chamber, they, in reply, will tell this country how they resolve these various issues. And in the event, the unlikely event that they agree with me publicly, I cannot speak to their private thoughts, but I don't expect that they will agree with me publicly. But if they dare to agree with me publicly, how do we resolve this? I go back to the statement made by the Honourable Minister for St. Peter, the Minister of Labour. The Honourable Member for St. Michael West Central and I continued on in the hope that we would not have had to go in this direction, that we would not have had to punish people in this country, that we would not have had to assume powers that the law says that we must not have as ministers. You don't have it. Why are you exercising it? Why do you purport to pass law that gives to you powers that the Constitution says that you cannot have? I am not anti-worker. I don't speak against workers today or any time. I speak in defense of the Constitution of this country. I speak against ministerial tyranny. That is what I speak against. I speak against ministers overstepping their responsibilities in law. That is what I speak against. That is what the voice must shout in relation to. That any right that is trampled, whether it is a corporate right or a civilian right, it must be defended. We as parliamentarians must be always careful against imposing on the rights of citizens, corporate or human. Let us continue to respect this Constitution. Let us embark on a legislative journey that always accords with the doctrine of the supremacy of the Constitution. Section 1 of the Constitution says it. It's one of the most important sections in that Constitution apart from the fundamental rights section. It says it is supreme. And we are subject to constitutional rule. And anytime we bring a law here, and it offends against that supreme law called the Constitution, and if it offends against Section 16 of the Constitution, it cannot pass. And if we pass it, we offend the Constitution. But then, sometimes some of us believe that political power and ministerial power is all that matters in this country. In other words, that we can do what we wish. We are politicians, we are ministers, we are powerful men. And every Thursday we sit and look at each other and smile and remind each other as to how powerful we are. And that two of us can get together and determine in the privacy of a plush office that a hotelier must surrender that which we gave to him some time ago in the nature of a concession. Something that a man looks forward to which a man looks forward to be more elegant. A concession. Property around which he would have structured his business financially. He is expecting to get that concession. He is expecting to get that concession on a specific date. And therefore he meets with, how ironic, his accountant. He meets with his accountant. And he tells his accountant, well, let us go forward in business. Let us invest, knowing that the government will give us X and Y as concession. That is property. And two ministers, one morning, say, no, you're not going to get it. I was at the point at which I referred to this right to appeal. There is, Your Honor, you know, the principle of natural justice. A principle that says that he who adjudicates must not have a bias. And I say to you, Minister, that a politician by his very nature has a bias. A hotelier in your constituency probably refused to contribute to your campaign. I wouldn't say in what sum. I wouldn't say in what sum. And I wouldn't say how the check would have got to you. But he refuses to make that contribution. And you determine that now is the time you have him. And you're going to take away his concession. That is bias. That is bias, Your Honor. That is bias, Minister. And so, if a person is likely to exercise his mind according to biases, he has offended against the principle of natural justice. And it is not, bias does not extend only to actual bias, Your Honor. But it extends beyond that. The likelihood, inherent bias, the bias that comes with the office. And so, Mr. Speaker, the minister finds himself on troubled constitutional and legal ground today. The other aspect of the rule of natural justice is that an adjudicator must not involve himself. He must not judge a case in which he is also tied up. He must not be a judge in his own cause. Now, if he goes, if the Honourable Minister for St. Peter, being the Minister of Labour, is the respondent, and I don't know that he is, but he having been caught up in the entire transaction of confiscation, can he go to the appeal as a respondent? Can he even go to the appeal as a party? And if he goes to the appeal as a party, an ordinary party, someone, for example, giving evidence or participating, he becomes a judge in his own cause. And the principle of natural justice spurns that behavior. And so, these are the difficulties that attend this legislation. My sympathies remain with the workers, and the sympathies of all of us must remain with the persons who are partners with the workers. Because there's a sense in which a man, an employee who meets his employer every day within the same confines, in spite of the tensions, in spite of the historical tensions, in spite of the difficulties, they're partners. They don't share in the profits equally, but in a very practical sense, an employer and his employee are partners in that business. Of course, one has the motive to make profit, and one has the desire to make a salary and to make a good salary. But within that arrangement of historical tension, within that arrangement of difference of purpose, they meet at the same place every day. And that is common purpose, to ensure that the business is run. And so, in that sense, Your Honor, a voice that urges for the defense of workers is a voice that must, by definition, also be urging the survival of the business. Because the Honourable Member for St. Peter will say to you and admit to you that his role and purpose is mediation. His role and purpose is to resolve those historical tensions that exist at the workplace. And in so resolving that, let us pass law that is likely to withstand scrutiny within the only branch of the state that has the authority to adjudicate the courts in this country. And in matters of labor law, it stretches from the courts to the Employment Rights Tribunal. That is a court as well. And I challenge the right of a minister to adjudicate on labor disputes. When we have in this country a highly sophisticated system, judicial system, that already provides for the adjudication of labor disputes. We used to do it in the magistrates' courts, and the Employment Rights Tribunal was established, and we had quicker hearings and quicker resolutions. But the law has never attempted to exclude the High Court, and labor disputes still go to the High Courts. But labor disputes cannot be adjudicated by a minister with inherent bias. And even if a minister does not have inherent or actual bias, the law deems that he is a creature of bias naturally. So, Minister, I challenge this legislation, not for its noble purpose, not against its noble purpose to defend the rights of workers, but for its possible offense. Let ideas contained even on the basis of law, but for its possible violation against the Constitution of this country, for its possible violation against the principle of natural justice, for its possible violation against the law. I will close by repeating that this legislation creates a very difficult relationship between two ministers. And at the end of the day, one is not sure about the powers that are distributed between those two ministers. And I've said it before, and it is worth repeating. Which minister becomes the principal actor in the decision to remove a tax concession, Your Honor? Which one? Who is the principal actor? Who is the offender? Who is the one that says to a hotelier or a businessman, I gave you a concession, and therefore I now revoke it? Now I expect that the law relating to concessions would have given the right to revoke. So I will not trespass there. Will not trespass there. But the right to revoke, again, is a discretion. It's a power. It's a ministerial power. It's a ministerial, yes, it is a ministerial power. And if it is stated in the statute that deals with concessions, that you can grant a concession, presumably, that act gives to the minister the right to revoke it. And it must be the minister responsible for tourism or maybe finance. Who knows? They're going to join a third minister? Who knows? We don't know. The public does not know. So we are asking these questions on behalf of the public. And I see the Honourable Minister for Finance now smiling. He thought that he was free of the accusations made in this speech. So, one punishes, one makes the decision to punish, the Minister of Labour. He goes to the Honourable Member for West Central, I assume. And do they also go to the Minister who gives and takes away, like the good Lord? Which of them? Which of them? Which of the three? Or is it a joint enterprise? Or do they act separately? If it is a joint enterprise, it becomes cloudy. The responsibilities become cloudy. But I say this, that you can remove or revoke a tax concession only if the statute allows you to revoke that concession. These are questions I've asked. These are questions I'm entitled to ask. These are questions, the answers to which the public is entitled to an answer. Which of the three in this joint enterprise that seeks to lawfully deprive an employer of that to which he has been promised by the state, a tax concession? And so, Your Honor, I've asked a number of questions, I've raised a number of legal issues, and I've raised them under your charge. And having so asked, I would expect, and the public would expect, that we would have some answers in the very near future. I'm obliged to you, sir.
Honourable Member for St. Michael West Central.
Thank you, Mr. Speaker. I must say that the leader of the opposition, who originates from Spooners Hill, Longak and Grisettes, obviously, yes, he originates from where I serve the people. He has family ties and other historical origins in there, and therefore, I will not take him on matters of the law, but suffice to say that I believe that the opportunity given today through the facilitation of this bill in this honorable chamber perhaps would allow us to have, and the attendant debate would have allow us that wonderful opportunity to tell the country why we have come here today. Mr. Speaker, I'm not a lawyer, and therefore I should not go down the realm of any legal debate. But I also know that industrial relations, that you also have sometimes to stand in defense of the worker. And Mr. Speaker, before I advance that point, let the country be under no misunderstandings whatsoever that whenever a bill is taken to the cabinet, and I'm not a very experienced cabinet member, but for what little I know, the bill has to be certified by the Attorney General of Barbados to be constitutional. And I know that. And therefore, when the Attorney General certifies that legislation or proposed legislation is lawful to take to the Parliament, then we have a duty, Mr. Speaker, to accept his advice because he's a lawyer and to come here and to debate. And the Attorney General does not stand alone, Mr. Speaker. But I'm not going to go too deeply into that, except to say that we are here today because the Prime Minister, when she addressed the country in her budget last year, stated in her budget speech that we ought to have dialogue and discussion with the Barbados Hotel and Tourism Association and with the Barbados Workers Union to ensure that the way forward would not be one of a rocky pathway, Mr. Speaker. The advice given by the Prime Minister was taken, and we made the decision that we would have what we refer to as a colloquium. Mr. Speaker, it is important to recall as well that Grantley Adams, our national hero, the right excellent Grantley Adams, would have had back in the 1950s to do almost the same thing we're doing here today, to set out a framework for how shop assistants were to be treated in this country, Mr. Speaker. And those of you who don't know the history, there were times when the shop assistant would have to come to work early in the morning and leave sometimes at midnight, go home to come back and sometimes work 7 days, Mr. Speaker. Would that be fair to any one of us in here today? Mr. Speaker, what Grantley Adams and others stood for, this is but a pure continuation of what we have to do to ensure that there's fairness for the workers in Barbados, Mr. Speaker. And if persons who are receiving concessions from the public purse must follow what we have proposed in a bill today, what it says, Mr. Speaker, is that if you are benefiting from concessions, like any other bill, there must be minimum standards to which you must subject yourself. And those minimum standards, Mr. Speaker, is not something that the Barbados Labour Party decided it would get up one morning and deal with. It was because of the conversation with the hoteliers and labor, Mr. Speaker, part of the stakeholder engagement process that would have allowed us, Mr. Speaker, to be where we are today. And I know, Mr. Speaker, that the people of Barbados are at the very center of tourism. And when we acknowledge and recognize that this industry is responsible in no small measure for our destiny, for our success, for our ability to earn foreign exchange, it is absolutely necessary that we follow the advice given to us and to ensure we have the conversation, the dialogue with the hoteliers and the union. The Honourable Member for St. Peter is correct. We ought not to be here, but we are here because we made several attempts to have the appropriate dialogue, and that is why we're here. And I am going to detail it, Mr. Speaker, because I am convinced that at the core of this debate, it has to be about equity, Mr. Speaker. It has to be about fairness, Mr. Speaker. And it has to be about accountability. Mr. Speaker, this debate is not intended to punish anybody. Far from. This debate, Mr. Speaker, is about individuals benefiting from the public purse, maintain minimum standards, and those individuals individuals ensure that they adhere to those standards. And therefore, Mr. Speaker, on September 13th of last year, we commenced discussions with the Barbados Hotel and Tourism Association, with the Barbados Workers Union. Those discussions were chaired by the Minister of Labor, and I was also there, Mr. Chairman, Mr. Speaker, to anchor. We set out what were the challenges facing the sector. The Barbados Hotel and Tourism Association had their opportunity to do the same, as did the Barbados Workers Union. We talked, Mr. Speaker, and engaged in a range of discussions. And Mr. Speaker, you represent people in this country. Private sector, public sector, you represent people, even constituents, Mr. Speaker. But if you were in those meetings, Mr. Speaker, and you heard what was said, you would have come to the conclusion that you are not living in Barbados, Mr. Speaker. I speak specifically, no holds barred this afternoon. None whatsoever. I come to this honorable chamber, full disclosure, former hotel executive for many years, having to work with the Barbados Workers Union, including, God bless him, LeVere Richards, Clifford Mears. Mr. Speaker, I apologize, I didn't ask your permission to call names. I forgot that, sir. Sir Roy Trotman and others. And I also come here to speak as a former president of the Barbados Employers Confederation, having served as president for about 8 years, and in other various capacities. Mr. Speaker, and having an executive responsibility for human resources for more than 1,000 hotel workers on the island. And Mr. Speaker, that is where I want to start. Because we heard from the workers of Barbados how they were being treated. And we listened. And we asked the other side to respond. And when we heard about workers being given short-term contracts for 3 months, Mr. Speaker, 6 months, and when they got to 9 months for an extension, the Employment Rights Act provision will be invoked and a break for the 42 days will be instituted to ensure that workers did not have the benefit of continuity of employment. I ask all honorable members in this chamber, and I ask all other persons, including management representatives and others outside of this chamber, if they were in that position, would they want to be treated the way that those workers would have been treated? Mr. Speaker, and if your owner of capital is all right because you own the asset, but when you're employed, would you like to be placed in that position? A position, Mr. Speaker, that you can't go and get credit. You can't get a mortgage, you can't buy a car. Mr. Speaker, this is not what Barbados is about and what it has become. And that's but one example. We had other examples, Mr. Speaker, in respect to the allocation and distribution and who should be the beneficiaries of service charge. Mr. Speaker, and I recall Sir Roy Trotman, one who attended one of the meetings on the advice of his General Secretary, repeated, I might add, the lecture, and he set out the philosophy regarding the distribution of service charge and why there is a service charge in the hotel sector, Mr. Speaker. Mr. Speaker, when persons were trained their best to redefine voluntarism in Barbados, Sir Roy, spoke at length to the issue. To the point too, Mr. Speaker, I might add, where one of the leaders of the association had to apologize to Sir Roy Trotman at one of our meetings. I said, Mr. Speaker, is no holds barred today. And Mr. Speaker, that meeting on September the 13th had a long list of concerns. And we didn't chide anybody. We listened. We encouraged the spirit of cooperation and dialogue. And we were there trying our best to make sure we brought change to the sector. Mr. Speaker, another issue. Would you believe that the Holidays with Pay Act was passed in this honorable place many years ago, Mr. Speaker? Many, many years ago. It set up the framework for how workers should be paid holiday pay, what we commonly refer to as vacation pay. And Mr. Speaker, it will shock you and other members that when we were having the discussion, that there were some workers, not all workers in the sector, who were not being paid their full vacation pay. And that's a fact. They weren't paid their full vacation pay under some construct that today we didn't understand. But that was one of the issues that surfaced in the debate, in the discussion. The whole issue, Mr. Speaker, of the deduction of union dues, what you call the check-off system, where if a worker decides to join a union and they want their money to be paid over, Mr. Speaker, that could be paid over to the union. Things, Mr. Speaker, that I thought had long passed. That was only but the meeting of September 13th, Mr. Speaker. Mr. Speaker, we met again on October the 2nd. And we met again to discuss solutions and how best we can bridge what was happening in Barbados. We even talk about a national retraining program. We talk about the National Tourism Transformation Program and their role and how they could help us. And we also, Mr. Speaker, talk about our protocol, because if we're going to pursue training, a protocol for the release of staff to attend training sessions. Mr. Speaker, we met again on October the 6th. And you might ask, Mr. Speaker, well, he can't be a very busy Minister of Tourism because he's meeting all the time here in Barbados, trying to flesh out issues, Mr. Speaker, that ought not to have occurred. So we met again on October the 6th. And specific worker concerns were raised. Mr. Speaker, it was but a sad sight to witness that you had to engage and listen to workers talking about how they're treated, the staff quarters, Mr. Speaker, talking about the fact that if you have half an hour for lunch and you don't have a meal provided, that you had to run down the gap, get a meal, sometimes go without a meal, Mr. Speaker. To hear about a meal allowance, Mr. Speaker. To talk about the transparency of service charge. And talking about, Mr. Speaker, union membership. Would you believe last year that we were discussing these issues? Mr. Speaker, we met. I had the opportunity, after I heard what I heard in the presence of the Minister of Labor, we agreed that I would meet with the hoteliers who were breaching certain fundamental procedures. Mr. Speaker, in one day, On October the 10th, I met with 5 hotels, Mr. Speaker. You would imagine how busy they had me, that I had to do part of the job during the day, and at night I had to stay in my office and do the other part of the job. Mr. Speaker, and we had to discuss. I fortunately had the weight of my human resources experience, and I spoke to them. One particular hotel, I'm not going to call the name, Mr. Speaker, who had a fundamental and a major issue, might add, with how workers were being contracted in Barbados. I spoke to them, I gave them the advice. And I didn't do it alone, Mr. Speaker, because I had the permanent secretary and the other advisors in the office with me. We talked them through, and in fairness to that one employer, we saw, through discussion, measurable progress. They had workers who were there for a number of years on a temporary contract, and the company agreed, subject to review by the union of the dates of employment, to recognize and honor those workers and move them from the state of flux, Mr. Speaker, to permanent employment, Mr. Speaker. Mr. Speaker, we also had meetings with the ground handlers in Barbados too, at the airport, because we recognized what was happening at the airport. And all of this, Mr. Speaker, was done to maintain industrial peace and stability. We met with the ground handlers on October the 11th. We had further meetings on October the 13th with the Department of Air Navigation Service and the Civil Aviation Authority, because it was not only related to the hotel sector. We met again on October 30th with the hoteliers, another group, a hotel group, sorry. November the 19th, sir. And you may ask why I'm detailing this, Mr. Speaker, because we have to be told how we got here. November the 17th, we met at the Lord Erskine Sandford Conference Center. And we had agreement, Mr. Speaker. And I didn't look to my note. I went to the note of the public officer who was there. We had agreements, Mr. Speaker, that no general manager, deputy general manager, or senior executive manager should be getting a service charge, Mr. Speaker. And that we're in any establishment that there was a service charge, that a service charge committee shall be established to govern the transparency of, a big word for integrity of the points service charge system, Mr. Speaker. I recall the Barbados Workers Union at that meeting asking for an investigation into the issue of service charge being collected but not being paid over, Mr. Speaker. And there were also discussions with respect to the no charges for staff uniform. Mr. Speaker, how could you in Barbados in 2024 give workers uniform and then want to charge them, Mr. Speaker? But when it was there in the hotel sector, and I have almost 30 years experience within the sector, Mr. Speaker, when I worked for the hotel company, and they were not only private equity owned, they were owned by they were owned and affiliated through the London stock market, Mr. Speaker. And not only that you had to treat workers fairly, you also had to ensure that you don't engage in modern-day slavery too, because some people feel that that's a new concept from the other side and can't understand it. But when you take a company public overseas, the whole set of things you have to agree to, including that you must not practice modern-day slavery. You can't get involved in human trafficking. And time would not allow me to go through the whole suite of things that you are not allowed to do. Yeah, Mr. Speaker, uniforms. And you also had the issue of staff quarters. We graciously put forward, and the union agreed, that improvements to staff quarters will be done on a phased basis to continue. Now, you may add, Mr. Speaker, some people will argue that not all hotels. And that probably is true. But, Mr. Speaker, when you want to have fairness in a system, you have to ensure that fairness is applied across the board, Mr. Speaker. We can't have one tax rate for the worker working at the NCC and another tax rate for the worker working at MTW. Can't work, Mr. Speaker. You have to have fairness. Mr. Speaker, we met again on November the 24th last year. And again, we thought we had agreement on those various heads. But we were recognizing, sir, that we were getting a lot of pushback, Mr. Speaker. And even though I recognize there was a lot of pushback, not from all hoteliers present, I give credit where credit belongs. But we were getting pushback. And when we thought that these issues would have been resolved, you start to hear the usual course. We have to go back to our membership. We have to sit down and discuss these matters when we had general agreement on November the 17th, Mr. Speaker. Mr. Speaker, there was an issue in respect of hoteliers who were not part of the collective bargaining process. Hotel companies that are out of the collective bargaining process. Mr. Speaker, I led HR for a hotel chain in Barbados, and I opted out of the collective agreement. But I wrote the General Secretary at the time a letter confirming that we will abide and maintain and follow the standards contained therein, and we did so, Mr. Speaker. But I had to remind the hoteliers that when the Employment Rights Act bill at the time was enacted and it became law, it set out very clearly that all terms and conditions of employment had to be accepted as part of the new contractual arrangements and what they refer to as statement of particulars. And that was done, Mr. Speaker. So you can't have somebody who was not part of the collective agreement post the Employment Rights Bill, but don't want to come and say that I can't be a part of it. Because terms of conditions, as you well know, Mr. Speaker, you're a lawyer, I'm not. It will go to the root and the heart of the contract of employment. And I'm not a lawyer, Mr. Speaker. And I told them, but if you don't honor the terms and conditions, then you will have what we call, no, not we, because I'm a lawyer, sir, what is referred to as constructive dismissal. That point was accepted, and we move on. And at all times, Mr. Speaker, and I have to give the honourable member for St. Peter credit, he was there at every meeting except when we had the individual meetings with individual hotel entities. He spent, like me, considerable time dealing with these issues, Mr. Speaker. Mr. Speaker, we met on December the 4th. We went through the agreement, Mr. Speaker. We agreed that we will have a protocol, a framework, Mr. Speaker. We thought we had agreement. Yes, it is true that the document was sent very late the night before, but these were all matters that we had agreed. And Mr. Speaker, I walked with a file because when you look at what the draft tourism protocol would refer to, Mr. Speaker, you would think that we were trying to tell everybody that this is going to be a new set of labor arrangements that they will have to follow. And Mr. Speaker, principally, almost everything contained in the draft protocol would have formed the basis for the collective bargaining agreement, which is currently in place with the Barbados Hotel and Tourism Association and the Barbados Workers Union. But that is the standard. The standard of fairness, Mr. Speaker. Their companies and their global companies will tell you that they are committed to the guarantee of fair treatment, Mr. Speaker. And Mr. Speaker, we owe it to the workers to ensure that they're highly motivated, that they can go to work and perform well. What sense does it make that I, as Minister of Tourism, traveling during the cold and during the heat, sometimes not having the good fortune of meeting with my constituents as I would like, trying to get business to Barbados, trying to get airlift to Barbados, and then on the one hand, you have a situation whereby the workers obviously feel mistreated. And when you feel mistreated, you cannot give of your best. You can try hard, but you can't give of your best. And we want growth in this country, in tourism. And if we want to have growth, it is complementary to ensure that the workers of Barbados are treated in a manner that can only be stated as being acceptable, Mr. Speaker. We can't go down this road to say to a person working in the hotel industry that you are entitled as a right to service charge is not harmful, Mr. Speaker, to any employer in Barbados. To say to them that they're entitled to a meal if you are providing a meal is not harmful, Mr. Speaker. To say that you should be treated not as chattel, Mr. Speaker, but you must be treated as a human being. And that if you are engaged working in a hotel company for a number of years, you should not be on a temporary contract for God knows how long. And Mr. Speaker, and one of the things that we did, one of the things that occurred at the time through the passage of the Employment Rights Act was a provision made to break a contract within 6 weeks, Mr. Speaker. I am now convinced that we're going to have to relook that. I'm not the Minister of Labour, but I have constituents in St. Michael West Central who work in hotels too. And the time may have to come where we have to look at that. Because I do not believe that you should be doing those things. If you have in a hotel sector, you have a category of permanent workers. If for whatever reason a worker is unable to come to work because he or she is sick, you will sit down and have the dialogue and you will have a temporary work arrangement. If you recognize and the employment rights gives an employer a right to be off sick for, I believe it's 12 months, then you can fill that gap with a temporary employee and have the discussion. But you know, Mr. Speaker, what was missing? It is that one person believe that they can change the voluntaristic system in this country. Well, it can't work because the voluntaristic system that we've practiced have been practiced going back to the 1950s and probably beyond, Mr. Speaker. Right? It can't work. Right? And if I said, in my opening remarks, that I serve as a former president of the Barbados Employers Confederation. And when the Employment Rights Bill was being discussed, there was dialogue and there was consultation. But eventually, it had to become law. And it became law. And Mr. Speaker, it wasn't in defense of a constitution either. It was because you recognize that there are certain practices that had to conform with what is fair and what is acceptable, Mr. Speaker. And Mr. Speaker, the protocol, we had a discussion, and there was no agreement. Mr. Speaker, we also had another meeting, December the 22nd. We reviewed the plan, we circulated to the stakeholders. The Barbados Hotel and Tourism Association requested further consultation. They said they will have a meeting via Zoom with their members. That was meant to happen, and then we regrouped the following on December the 28th. Mr. Speaker, after about 12 meetings, separate and apart from the individual meetings that I had with the Minister of Labour on this matter, we had, Mr. Speaker, at least 12 meetings. But Mr. Speaker, it comes to a point when you can't keep talking and talking and talking, there comes a time when you have to act. And when you are talking to people, Mr. Speaker, who sometimes could be very disrespectful. And Mr. Speaker, you know, they say a lot of talk, you hear a lot of old talk, Mr. Speaker, on the ground that we can, in a room with the Prime Minister, we can't talk, Mr. Speaker. I hear that all the time. And that the Prime Minister, they want to give the impression that the Prime Minister is this large and in charge person and that people who sit in the cabinet don't talk. But Mr. Speaker, I could dispel that right here now. That is a lot of nonsense, Mr. Speaker. A lot of foolishness that when you reach a point and you're trying to make change and impact change in a country, that you have people who don't even sit in a cabinet but won't come out and tell you that you, Gadinejo, you can't talk, you can't say anything. But people who know Gadinejo know that that's not true. But, and the beauty about it, I don't have as much experience as other cabinet members. But when I first joined the cabinet, and I can't disclose anything because I can't afford to be locked up on the Official Secrets Act. But I've seen the Prime Minister at work. Yes, any good leader will have to drive the process for success. But that's only we get 30-0. If you don't work hard, you can't get 30 seats. You gotta work hard to get 30 seats, Mr. Speaker. Right? And if she does not drive me and other members, Mr. Speaker, but then when tourism arrivals numbers go down, Mr. Speaker, I'll be looking for a job. Because I serve at the pleasure of the Prime Minister, Mr. Speaker. But you have some people out there who will put out the myth and tell you, oh, you can't say a word. Mr. Speaker, that I really want to say to the country. Ignore all of that. All of that, Mr. Speaker. But when you have individuals, Mr. Speaker, who will want to promote something that editor have not seen, Mr. Speaker, the office of Prime Ministers must at all times be respected, sir. Whether you like the Prime Minister or not, the office must be respected, Mr. Speaker. But when you have an individual, not going to call any names, Mr. Speaker. I didn't apply to you for permission, but I'm not going to call names. But when you have an individual leading an association, and I recall, because it happened in my presence, I saw it, March last year, before I came in here to speak on the budget, that individual picked up her bags, Mr. Speaker, to walk out of the Senate chamber we were meeting in the presence of the Prime Minister and other members of the private sector, including the Hotel Association and owners of capital, Mr. Speaker. It happened, Mr. Speaker. I haven't said a word about it until now, but you have to say these things, Mr. Speaker, because the country must know where we are and where we are going, Mr. Speaker. And then again, most recently, we witnessed it. But no one person can change the voluntaristic system that we have in Barbados. None, Mr. Speaker. Because if we were to allow that, Mr. Speaker, we'd be walking back from everything that Right Excellent Sir Grantley Herbert Adams would have fought for in Barbados. We'd be walking back from everything that successive Barbados Labour Party administrations have fought for in this country to ensure there's a better quality of life for our people, Mr. Speaker. And when I tell you I come here with no holds barred, Mr. Speaker, I say it and I mean it. And I said earlier that even the head of that association at one of our meetings had to apologize to Sir Roy Trotman of the Barbados Workers Union, Mr. Speaker. It is a matter that is on record. And we've got to stop this, Mr. Speaker. Whether you like me or don't like you, don't say anything. When I took up the job, the person levels some criticism at me, Mr. Speaker, but I say, no, my time can come, and I came in here, the budget, I didn't call the Prime Minister name, because the Prime Minister warned me, don't go in there and do anything. I didn't call the person's name, but the country knew I was referring to her. But, Mr. Speaker, I say all that to say that do not believe that we are mad men and women in the Barbados Labour Party, and that we don't have vision, and that we don't have the ability for flexibility and so on. We did, Mr. Speaker. We met with them, I told you, at least 12 times. The Minister of Labour was there with me. The Prime Minister was there with us on at least 2 occasions, I recall, the first meeting. And we are doing all of this because we want industrial peace and harmony in Barbados. You cannot allow a country rebounding after COVID that needs income to pay our way and to pay our bills and to earn foreign currency to fall into a state where we could have industrial disputes, Mr. Speaker. It does not make sense. There'll be no winners in this equation. And we made that point time and time again. Others got it. But some others believe that they are like lords above and that they're in charge. Mr. Speaker, I want to say, it is not for a lack of effort and trying, Mr. Speaker. And like I said to you, the tourism framework that we set out contain minimum standards, Mr. Speaker, and some of the same standards that you already have in a collective agreement. And what is it? And why is it that you should have one standard applied only to unionized properties and another standard applied to other properties. It's a basic standard. And you heard the honorable member for St. Peter made the point. There's a minimum standard, and he outlined the process by which you will follow. So it's not that I am going to decide that somebody didn't give me a campaign contribution and that I will go after it, Mr. Speaker. But I don't even like taking from them, so it wouldn't bother me at all. Right? It wouldn't bother me at all, Mr. Speaker. But the issue here, Mr. Speaker, has to be that this Barbados Labour Party, through the Minister of Labour, the Honourable Member for St. Peter, and this Minister, Honourable Member for St. Michael West Central, that we gave it our best shot trying to bring it to conclusion. We even told, when we thought we had an agreement, communicated to the Prime Minister that we believe we have an agreement. But when you walk back on agreements, Mr. Speaker, this is where you then have to say the bridge has now become divided. And that is what happened, Mr. Speaker. But if I have, Mr. Speaker, to stand in defense of what is good, I am prepared to do that, Mr. Speaker. You have to stand up for what you believe in, and you have to stand for a good cause, Mr. Speaker, and for good reason. And I say to you, and let the word go out, this is not about legislation to punish anybody. You have a right to choose. You maintain the minimum standard, or you don't apply. It is simple as that, Mr. Speaker. And this is not about an opportunity for individuals to believe that we are back in some dark days. That is not what we're about, Mr. Speaker. We are here, Mr. Speaker, to ensure that the frameworks that we put in place, that there's fair treatment meted out to workers, that there's fair and balanced approaches to how you access concessions. It is about if you are doing good, Mr. Speaker. And I say to those who are currently engaged in good practices, you have absolutely nothing to fear. Absolutely nothing to fear, Mr. Speaker. But if you know that you want to go in a direction that could be described only as unacceptable, then of course the government has a duty to step in and to ensure that the rights of persons are maintained and upheld. And that is what we're doing. So, Mr. Speaker, you can't be thinking about a tourism industry and not thinking about the way forward. Not talking about retraining and ongoing training, Mr. Speaker. You can't have, like I said, delegations leaving Barbados trying to get additional business to this country, and that we are on the precipice of despair and the potential exists where you could have dislocation. And Mr. Speaker, what is there to be feared in the legislation? There's nothing to be feared in legislation. Absolutely nothing. It says if you want to be a beneficiary of concessions, then you have to agree to minimum standards. And if the minimum standards that we've had in the collective agreement for years, if those standards don't mean anything, then where are we likely to go? And I say it to you, Mr. Speaker, because I know in the interest of time, I'll have to wrap up, that this, I will commend the Minister of Labour and his officials at the Ministry of Labour for putting this together. I also have to say that the Minister of Labour, I believe it's Job in the Bible, and he will correct me if I'm wrong, like me, had great patience. I told the hoteliers, and I repeat it in the public domain, I say, where you are going, you do not want to go. I warned them, Mr. Speaker, you do not want to go here. Let us sit down and agree the protocol. I spent so much time and energy, neglected my constituents in Michael West Central evenings, like they all remember there for St. Peter. Staying in rooms for hours upon hours, Mr. Speaker. Could you imagine, Mr. Speaker, when I should be in my constituency in December, that I hear a meeting, as I told you, I meeting in December, Mr. Speaker. 2 days before Christmas, they all remember, for St. Peter reminds me. And then, you know, as soon as you get over Christmas and Boxing Day, you're going to another meeting, Mr. Speaker.
Your honourable member has 2 more minutes.
So, Mr. Speaker, I say all that to say that we are where we are today, not because we didn't have dialogue. We are here today because of an action on the part of some who felt that they should not be a party to what is right. I stay here as a representative for the people of St. Michael West Central. And the people of St. Michael West Central sent me here to ensure that their interest is protected. And I want to say to the people of St. Michael West Central, and I want to say to all the hotel workers, that I will never forget whence I came, and I will always remain true to my heritage. And I commend this bill, Mr. Speaker, to this honourable chamber. Thank you.
Honourable member St. George North.
Thank you, Mr. Speaker. Mr. Speaker, we convene today to deliberate a bill to engage in a debate, one which I firmly believe is one of the most important debates for workers in this country in a post-independence Barbados. Indeed, it is a debate that I define as very important, a defining moment in my tenure as a parliamentarian. Mr. Speaker, you heard the Honourable member from St. Peter in his presentation recall how just 1 month after the goodly people of St. George North gave their approval of my candidacy, how as a representative of the Executive Council of the Barbados Workers Union, I didn't just come out to knock on a door, but to kick in a door, causing the government of Barbados to understand that it was time for leveling the playing field. You heard how it came out of a dispute with the largest security firm in this country. A dispute that led to a leveling of the playing field, a minimum wage established at $9.50 for workers in security. And that catapulted what some may easily recall only as an election promise, a manifesto promise to deliver on an $8 national minimum wage. But it went beyond that to ensure that all other workers, not just those in security, but all other workers got the benefit of a national minimum that was set at $8.50. Indeed, it was a high-stakes dispute. And notwithstanding all the commitments to operate similarly to deliver a minimum wage, it was on the heels of the workers in security and through the direct efforts of the Barbados Workers Union that was delivered not only for those security workers, but that all workers in Barbados can enjoy a national minimum rate. Mr. Speaker, it would be remiss of me if I didn't signal, though, that 3 years after that national minimum wage was established, where one would easily recall, or should easily recall, my voice signaling a call that while it represented an important first step, that $8.50 was not good enough. And it saddens me, Mr. Speaker, that 3 years on, April 1st will be 3 years that the Minimum Wage Board has not met once to correct that minimum and bring that minimum closer to a point where we could feel proud that the thunderous applause we gave when that was passed is something that we would continue to make good on. The minimum wage has to be fixed. It was not good enough at $8.50 back in 2021, but it was recognized as a start. In 2024, the signal comes that if the minimum wage board can't meet for whatever reason, dismantle that and get a fresh minimum wage board that will deliver for the workers of this country. But Mr. Speaker, let's not dwell solely on past victories or on the current shortcomings, those which I just mentioned. The Honourable Member for St. Peter already spoke well of the role that the labour movement through the Barbados Workers Union played in securing increases in wages and allowances for the public sector, the appointments that we heard of, the improvements to the safety and health at work legislation. Today, I will focus on the important role that the labour movement through the Barbados Workers Union plays in giving teeth to the 1952 Labour Contracts Act. As you heard, very eloquently put from the Honourable Member for St. Peter, that arose out of a dispute with a construction giant in this country who worked with the union through the BEC to ensure that minimal wages could be set in this country for construction that not only guaranteed workers the opportunity to receive comparable wages when a company is engaging in public contract, but that provided an opportunity to prevent employers who were doing good by their workers not to be undercut through underbidding that could happen only because a competitor pays significantly less. And I say, and you may have heard me stress on when engaging in public contracts, because the sad reality is that the labor clauses, public contracts legislation only sets that minimum standard if a company, a private company, wants to benefit from a government contract. The sad reality is, therefore, that you can be engaged in a government contract today and you have to honor these standards. But tomorrow, because you are engaged in your private capacity, you don't have to honor the standards. So that in terms of making parallels between labor clauses or labor contracts and a minimum wage is standard every day across the board. Labor contracts only says if you want to benefit from the public purse, you pay minimum. In the same way that we will come to the labor concessions shortly. If you want to benefit from a concession, do right. That's the caveat. It shouldn't be seen as a punishment. It shouldn't be seen as anything being removed from you if you intend to do right by people. The principle is as simple as it is non-negotiable, and that has been the view that the Barbados Workers Union has been putting out there. Companies should neither gain advantage over competition in any sector by offering or doing significantly less by workers and refusing to assure workers minimum standards of decency. That's what collective agreements are about too. Not setting a ceiling on standards, but setting a floor below which no one should be allowed to fall except in breach or in contravention of what the agreement was. Mr. Speaker, sir, I said the time is right. Perhaps right is not the word, but overdue for another order, though, to address the conditions in the construction sector that go beyond wages. Those conditions such as safety and health that will see some employers in construction not providing PPE, making workers pay for PPE to come on the job. All of these are things that we signaled back then last year when we dealt with the wages component that we were going to come back to, and we have to hasten our steps in that regard. So, Mr. Speaker, before I move on, I want to assure this honorable House that I have not come here either to mix words, because it is clear to me that the battle lines have been drawn, not just for decent work and fair labor practices, but for the soul of the labor laws and the impact that they will have and they should have on working people in this country. I did not put my integrity on the line in 2020 to join this party, to come in here not to be able to influence change. And I only make reference to my integrity because I remember just days after becoming the first female General Secretary of the Barbados Workers Union in 2014, doing an interview and saying, no, it's not my belief that at this stage we have to concern ourselves as a union with aligning to any political party. I said that because I think that in our mature system of industrial relations, we have moved past the need to hold on to the skirts, the hems of the political influencers, because we had seen progress across negotiations in the public sector and in the private sector. And I could look back and perhaps consider it as a naive thought of mine that it would not be necessary. But up came COVID. Up came COVID, and across Barbados and the rest of the world, the experience of workers was that the rights, the hard-fought-for rights and benefits that they had over the years were being repealed. The experience of workers was that this is a force majeure situation, COVID that is, on employers. So it's okay for us to put our hands in your salaries and wages and extract for them. And because now you, the workers, you need us, because if you can put bread on the table and so on, it's like you accept this unilateral movement on our part, or go your way, we will find somebody else that wants to do the job. During COVID as well, we saw that many of the frontline people who had to keep countries together were not only the legislators and so on. The frontline people, the people who had to go there physically were who? The gas station attendants, the supermarket workers, the workers in sanitation, the workers in water resources, the workers in our ports, the salt of the earth, therefore, that had to compromise their own house. And when I say the workers in the port, special shout out to those workers who had to be working in confined spaces to ensure that in a trying circumstance, we still had food on our table, we still could access the products that will keep all of our heads above water. Mr. Speaker, today, I am profoundly aware of the gravity of this moment. This debate is one which transcends boundaries of mere policy. It is testament, I believe, to our collective resolve to champion the rights and dignity of the working class in Barbados. A colleague of mine recently shared a quote that has deeply resonated with me, especially now. You have to take the opportunity of a lifetime within the lifetime of that opportunity. You have to take the opportunity of a lifetime in the lifetime of that opportunity. I don't make any bones about the fact that I seize any and every opportunity to deliver on behalf of working people in Barbados and their families. We are here not just as lawmakers, but as custodians of justice and equity. And I'm conscious, Mr. Speaker, that we do so not only under the hopeful gaze of our constituents, but today we do so under the hopeful gaze of those who represent workers in a sector of this economy that will benefit most significantly from the passage of this legislation. And I take this opportunity to salute and greet those who represent the hotel sector here in this chamber visiting with us today. The bill we are debating is not just a legislative proposal. It is the embodiment of our commitment to workers in Barbados. With the passage of this bill, all of us are setting a national example as legislators to our commitment to decent work, fair labor practices, specifically in managing those relationships with the Prime Minister, with the private sector, where public spending, or put another way, taxpayers' monies are involved. Sir, permit me to tell the story of a dedicated hotel worker who is here with us today, but whose name I will not call, who epitomizes the urgency and necessity of this bill. She bravely shared her harrowing experience across social media. And I believe that many of us in here and those listening would have heard it. She was not speaking for herself when she told the story of not being able to access credit, even to buy a table to put a TV on. She was not speaking for herself when she expressed that even alongside her husband, who is a security guard, that their combined wages could not deliver hope to them in the form of a home. Her testimony of being denied financial dignity, her testimony of being unable to do for her family or guarantee for her family the comforts that many of us take for granted, let alone to access things like mortgage and contribute to education fund and so on. Her story was not just one of personal struggle. Her story reflected the systemic injustices that occur when workers have to come to work and be subjected to the inconveniences and the insecurity of short-term contracts, because that is why she can access these things. Because if you don't have a contract that offers guarantee to those who are lending on paper, you are denied opportunity. Her courage did not go unnoticed, and it galvanized support from many who wanted to help her, many who also wanted to add their voices to the union's call for dignity and respect. A recipe for respect was the campaign mounted for hotel workers. Mr. Speaker, I believe that, like most of us, I am the product of the plantation. My maternal grandmother was a shop steward in the Barbados Workers Union in sugar. One of the 3 strong women that they told me would be, with the right excellent Sir Frank Walcott, wherever there was a meeting in sugar. Whenever there was a meeting, for that matter. My paternal grandfather was a B in every respect. But on this occasion, I'm speaking about the B, meaning a BW member, solid BW member as well. I'm raising the issue of sugar and the plantation at this point. And I had cause during the colloquium meetings, that word, the colloquium meetings, to expand on it. Because in many respects, the plantation represented the continuation of colonial servitude. And that is notwithstanding the experience of 1937. Mr. Speaker, the specter of sugar looms large in our history, emblematic of an era where the sweat and blood of our ancestors fuel the engines of colonial prosperity. Sugar was once king. And I had cause to question myself, how come if sugar was king, my maternal grandmother and my paternal grandfather died poor? Their lives banked beneath the relentless sun on the plantation, spent in service to King Sugar, only to be rewarded with poverty and hardship that ended only at the point of their death. Fast forward, Mr. Speaker, to the 1980s, when economic dominance was passed from King Sugar to Queen Tourism. The struggle remained fundamentally. It remained unchanged. For over 6 decades, the Barbados Workers Union has tirelessly negotiated with the BHTA by whatever name, at one point Barbados Hotels and Catering and so on. The Barbados Workers Union, in negotiating with them, were driven by a singular mission. A mission to make sure that theirs would not be the lot of those who spent their lives serving King Sugar and who had to die poor. We have fought to break the chains of poverty, ensuring that the transition from King Sugar to tourism did not simply replace one form of servitude with another. And I heard one of my parliamentary colleagues earlier speak to it in terms that many would think would only come from the crass labor movement. It's a form of modern-day slavery. Despite our strides, Mr. Speaker, despite all the efforts that we have made or taken to ensure that workers continue to benefit from the sweat of their labor, despite all the efforts that have been made to ensure that the ripple effects of colonial servitude are not continually felt by those who give themselves to making this country better. Despite all of that, we would hear the criticism of those, Mr. Speaker, who don't look like how Master used to look when Sugar was king, but who look like most of us in here, who went to school at the same places as most of us in here, who even sat in Sunday school with most of us in here. But theirs, Mr. Speaker, is one that perpetuates the exploitation that we identified as coming with a master who did not look like us. So if we get into the essence of this debate, it becomes critical to articulate the multifaceted challenges that our workers, especially those in the hotel sector, face on a daily basis. These are not isolated incidents, but systemic issues. And although I had resistance to the word colloquium because of what my understanding of it suggested, and I prefer just straight talk. Mr. Speaker, those sessions, I am happy that in the end, they were able to demonstrate that the workers' claims were not claims that were being made that could not be justified. When I talk about the challenges, Mr. Speaker, the challenges of service charge. From 1976, in December, by collective agreement, the categories of workers that should be covered by service charge were well established, not to include managers. But we had to be treating to issues and complaints by workers, either that they were not receiving service charge or they were receiving less service charge than they should receive because managers were also benefiting from the service charge. Then another vexing issue was the issue of meal allowances. But before I go on to that, I hasten to point out that it was the very hotels that introduced the concept of service charge, you know. This was when the late Frank Walcott wanted an over 40% increase in wages. And it was their solution to make sure that guests coming to hotels would pay a service charge, and that 98% of that service charge would go towards distribution among workers, so that in fact, when you see, if you look at any of the collective agreements now, and you look at the appendix that speaks to wages, you may very well wonder, how comes negotiations going on for all these years, but these wages still look very paltry, whammy-palmy. But it was never intended to be like that, because as a compromise for all the heavy increases in wages that the employers would have to carry for a cost, they charged guests coming to their establishment the 10% at the time. It has been modified upward now in many instances. The 10% at that time, when it was first introduced in the 1960s, and 98% of that, whatever was collected, was distributed among workers in a manner that the wages and the service charge offered no different. So that in many respects, the total compensation of workers was at least 1.7 times. And in some cases at the luxury class hotels, sometimes twice as much as what the basic wage was. So workers had to be making a claim of no service charge, which has implications on total compensation. Then we had the issue of the meals. Now, I'm fortunate that mine is an organization that keeps good record. And for the meals, back in 1969, the BHTA found itself having to adjust how it applied vacation pay to workers in the hotel sector who were going off on vacation leave, because they were not including the $2 that was the substitute for the meal allowance back then. Once you were on property, you got a meal that included two starches, vegetables, a meat or fish. That's for lunch and dinner. And breakfast had its own standard. But once a worker was going off on vacation where they could not get the meal, $2 was the meal replacement value in 1967. Now, if $2 was the meal replacement value in 1967, now pray tell me why in 2024 we should be debating $8. When I don't know the calculations, the fancy calculations for the time value of money, but where those that I've reached out to at the central bank have assured me that between 1967 and now, inflation has grown in the region of 1,800%, which tells me that a meal replacement value of $2 in 1967 has to be now about what? 18 times 2, at least $36. And I understand from those who negotiate for workers in the hotel sector that we stuck at a union insisting that a value has to be at least in the range of $25. And hoteliers saying, well, we could produce the meal at about $10 or $8, so that's what we're willing to pay. That is what we want you to give. We really don't want the meal replacement value. We want the meals, because there was never a value given to meals, because as we heard back in the day, a gentleman's agreement meant that. So when there was agreement on meals, hotels actually provided meals so that the value of a meal only ever came into play when people proceeded on vacation. We want to go back. So if you can produce the meals at $8 and $10, feed the people at $8 and $10 so that the idea of a meal replacement value is not one that has to be on the table. The workers, so where we are debating $8 is because over the years, that was not considered an important part of the negotiation for revision, because you didn't have the issue of people coming into work, and as we heard it during those colloquial meetings, experiencing employers throwing away food rather than giving it to them. We didn't have that experience through the years. And workers, because they were benefiting so well from service charge, didn't squabble over whether when they go home on vacation, they only get $8 for the value of a meal or anything like that. They didn't have to, because gentlemen were party to an agreement, and gentle ladies, I believe, Honourable Member for St. Peter, were party to an agreement which they honored in such a way that people didn't used to sweat the small stuff. But now we got sweat everything. And it would be the desire of many as well, it would seem, to have workers and their representatives fielding grievance after grievance every week. There's not a day that goes by that a grievance does not arise from hotels. I understand that the Labor Department has at least 200 cases before them for consideration in hotels. So there are people that will prefer for us to be fighting these things on a daily basis, rather than legislating them in a way that the protection is guaranteed. We continue to be confronted by powerful forces who would prefer us, instead of passing this piece of legislation, to rely on the goodwill of those who profit by exploiting workers. Well, that is not the case in every instance. It is where those noises are loudest that we are finding it. And I hasten to say that there is a myth out there that every time a trade union speaks, or when people speak in defense of workers, that you're categorizing every other employer as bad. That is not the case. But where employers are ashamed of some of their own colleagues committing these acts against workers, and where they, through their associations, cannot control them, and where by collective agreement it has become impossible to monitor and deliver for workers in a real-time and tangible way, something else has to be done. And so I'm proud of the organization that I lead, that on the 17th of November proposed that, look, you know what? Let's dust off the Labor Convention of 1949 that this country ratified back in 1952, and let us look to the recommendation that accompanied it. A recommendation that said member states should take every step to ensure that whatever is done for the labor contracts aspect of it is applied to private companies that benefit from subsidies and utilities. So there are those who prefer us to see us protest and so on, but this labor movement is past that. The workers of this country and their families deserve better. Mr. Speaker, the hotel workers who have rallied throughout the course of the last few months to ensure that we could reach to this day where within their grasp is the restoration of dignity. Within their grasp is the restoration of respect. These are the workers that must be saluted. Mr. Speaker, as we stand on the precipice of change, I invite all Barbadians to envision a future sculpted by the passage of this legislation, a future where the dignity of every worker is not just acknowledged, but enshrined in our law. Mr. Speaker, I imagine in the coming weeks and months of Barbados where every worker from the bustling streets of Christchurch to St. Lucie, passing through St. George, is guaranteed a wage that not only meets their basic needs, but allows them to thrive. We can picture those workers who, with contracts guaranteed to them, are able to go and stand before stores out there, you wouldn't call any names, stores out there and receive credit, will be able to go and face a finance company and be guaranteed a mortgage certificate that can see them making better for themselves and their families, that can ensure that their child or their children don't only get by if they get a little blight from somebody, but that they themselves can be responsible for helping their families to be better than they actually were. Imagine the transformative impact on the small businesses, though. Small businesses and entrepreneurs, not only workers, who buoyed by a workforce that is now motivated, healthy, secure. That workforce now can drive innovation and competitiveness and deliver on productivity in a way that when repressed and when suppressed by the bondage of exploitation, they cannot. Barbados can become that beacon, that example of sustainable development and social justice. Contrary to what the critics will say, benefiting from and attracting investment and tourism. It was our experience, and it continues to be our experience, that even when we go through the hotels and so on, and sometimes the tourists hear some of the complaints that come, they're concerned. They're concerned because they wouldn't expect that people who are delivering such good service are subject to these kind of terms and conditions. Our people continue to deliver. Imagine how much more they can deliver when treated with respect. As I wrap up, Mr. Speaker, I am emphatically saying that by passing this bill, we are not only safeguarding rights of our workers, but investing in the prosperity and well-being of future generations. I call upon each of us. I call upon each of us to stand on the right side of history, no matter what our persuasion is. I urge us all to stand on the right side of history. Let us pass this bill with a unified voice, signaling to the world that Barbados values well-being. Mr. Speaker, just before I conclude, though, permit me to touch on a related issue, an issue related to labor contracts and labor concessions, an issue that regards or relates to the Employment Rights Tribunal. Over the past few years, the Employment Rights Tribunal, over the past 5 years at least, has made a number of awards to workers and ex-workers who the tribunals recognize were unfairly dismissed. But guess what? Having won these cases, having been given an award or a verdict that award is granted or should be granted by a company, many workers find themselves 3 years on, 4 years on, and the money has not been paid. There's no appeal on a point of law. An award of $30,000, $40,000, and that money has not been paid. And the question that I have for this honorable chamber is, in the same way we consider labor contracts, and in the same way that we consider labor concessions, isn't it fitting that where companies perpetuate a situation that justice delayed is justice denied, that the Labor Contracts Act be amended or extended to address those as well? You shouldn't be going wrong and seeing a employer plaque, signage, big and bold on government projects, when it is proven that the unfair people and they're refusing to pay them. These are the kinds of challenges experienced on the backs of poor people that I have presented myself to be a part of a government and to serve in this honorable chamber to deal with. And we can go through them one by one by one, with the will of the people to allow me to deliver in this regard. So that's the employment rights contract, Mr. Speaker. Notice of this question has been served and will certainly be followed up as it relates to the Employment Rights Act. With these words, Mr. Speaker, I want us to remember this debate. I want us to remember the faces and stories of all those that we have sworn to serve, whether they voted for us or not. Some of them are in the room with us here today. They forcefully wanted to be here today to follow this debate. Our duty is to them. Let us remember that our actions today, the actions that we take in defense of workers, the bigger picture, don't let's focus ourselves too much with some of the issues that will distract. And while I say that, there's another question that really arises. Because if a concession is understood to be given without caveat, in other words, if a concession is a right, and not a discretion, then the question would be, if we are to make right on this bill once passed in Parliament, whether or not you rescind all the concessions and grant them back with the caveat, I have not read law. But my understanding is that a concession as a discretion means that there's some proviso or caveat. If you don't do something, something might happen. So I'm really also looking forward to the honorable member in his reply to clarify in my head, if that is not so, then if it could be possible at all, that maybe the concessions could be rescinded, the discretionary concessions, and reissued with the caveat that if you don't do right by workers, that you don't get them, not punitive, because if you don't want them, if you don't want a concession, you don't have to observe the standards. That's the difference between this piece of legislation and the minimum wage, as I said before. But if you want the concessions, and most of the people that complaining clearly want them, otherwise they would have said they don't want them. If you want the concessions, move right. Do right. Do right by the workers of this country. Do right by the workers and their families. Mr. Speaker, I thank you for the time you've allowed me. I'm obliged.
Honourable Member for St. Joseph.
Speaker, I beg to move that we do now suspend the sitting until 3:30.
Question is that this honorable chamber be suspended until 3:30 p.m. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it. This honorable chamber stands suspended until 3:30 p.m.